Well, good evening. Good evening. Happy Friday, January 17th of the year 2025. Glad to see you guys here. Hope you had a wonderful week. It is indeed Friday Night Frenzy, where we're going to talk about some very interesting developments in the law. You know, the week started nice and calm. I don't know if anything about this year has started calm, but it seemed like the week was going to be an adjustment back to normal. You know, the first week back, you had all that snow up here or down here, wherever I am, which caused the kids to be locked inside, which caused the parents to be crazy. And I guess some of that craziness just passed right on to certain litigants because what started as a very boring week um, had some twists and turns. So in the last 3 days, I think we had TikTok decision came down from the Supreme Court. We talked about that, so we're going to review that. We had Diddy making some interesting claims, and we had Justin Baldoni drop a 179-page lawsuit against Blake Lively and Ryan Reynolds. And then there's the fun stuff we can talk about too, like 3D printing stuff. So speaking of 3D printing stuff, I don't know why I even came up. In the chat, please behave. Mini mischiefs are allowed to watch for at least 10 minutes, I believe. So we're going to keep some of the chaos to a PG tone for a little bit, with one exception. Well, not one exception. So exciting happenings in this household. I got a new 3D printer. So a new one. I had to order it, and it came in. And I am now kicking myself for not having ordered it prior, because it is about 3 times faster than my old printer and has capabilities like I just could not contemplate. So this entire week has been Rob's jaw on floor as things print. And among those things that printed is this little guy. This is a little Benchy. So we'll talk about him in a little bit. Now, the other thing that printed is something that I don't know if one of the minis has seen yet. It is, in fact, a glow-in-the-dark samurai sword. I'm a child. I am such a child. Leo hated that noise as this thing. I could hear him jumping around upstairs. I printed this before realizing that I created a weapon with a couple of kids of chaos that are in the house. So we're gonna have to find a really tall place to hide this. I'm never gonna grow up. Never, ever, ever, ever. I will definitely grow old, but I am never growing up. So yes, I printed it, and it glows in the dark. It glows in the dark. So, you know, thing is, the problem with the 3D printer is when you're about to go to bed, you realize these are several hours that a machine could be operating without you needing to directly supervise. Hours that are or could be productively used by a machine operating the household. So you set the machine to work and you go to bed and you wake up and there's a 3D printed samurai sword waiting for you in the morning. Oh, yeah. Yeah. This is fun. This is fun. So that was some of the interesting stuff that happened in the household. Uh, to be fair, Mischief Manager has taken this all in stride, and we are very happy about a lot of the things, I think. So, anyways, how you guys doing? How was your week? How was everyone? How was the, I believe, third week back? Oh, look, Paralegal Liz. Hey Liz, how you doing? Good to see you here. Christy Austin, new printer for new pickles. No, those botched prints are gonna just. These are just gonna we're just gonna let those fall by the wayside, and we're not gonna talk about them right now because there are minis watching. So, where are you guys tuning in from? Do you have a cocktail in hand? How's the weather where you are? Is it still as freezing cold as it has been here? I know that I say that, and I'm going to piss off a lot of Canadians in the chat. You print a bird's nest? I can't print a bird's nest because the printer I have auto detects the bird's nest and stops. It's funny. Living life now, I miss Ghostblade. Yeah, that was kind of a hearkening to the Ghostblade days. So that was definitely there so that we could relive some of those lovely memories. And you know what's really funny about it? I bet later on in the live stream, when we get to too much chaos, we might get the unicorn hoodie with oh god, this is I can't even say this. We might get the unicorn hoodie with the glow in the dark sword while we're printing a Benchy talking about the copyright issues with regard to Benchies. So I guess we'll just have to see how all of this plays out. A wild Runkle has been spoken to. He will likely be here at some point in time. Syracuse Brad, good seeing you here. Good idea. Officer's got a new 3D printer. Need to find print file for Samurai Sword. Well, I don't know if the office printer needs that. But I'm now convinced. I now understand why people have multiple 3D printers. I am absolutely convinced. So we got Springfield, Illinois in the house. Hey, Carol. Fort Smith, Arkansas, Illinois, Indiana, and it's snowy. Alabama, New Hampshire, Nevada. Everyone tuning in. Snowy where you are, Jelly Bean. Oh, yeah. Adult money for adult toys. That is exactly how that works. Laura M. Lawn Lumber, Ireland, where I had a hard week from chronic illness flare up. Oh no. So tonight I ordered myself some pretty new gel pens. See, pretty new gel pens are a great distraction to the annoyance of chronic pain. And hopefully we can talk about some stuff that's not entirely, well, hopefully we won't add to that pain. Promise. Spain is in the house. Wisconsin, South Jersey and Pepsi, New York City, it's cold, Florida, and it's cold in hey, I feel like me saying it's cold in Virginia. I don't feel like people in Florida get to say it's cold ever. So Calypson's Vixen's coming in saying, give love to the mods. Yes, please give love to the mods. They do wonderful, wonderful help for the channel. Buildsboro, Pennsylvania. Vancouver Island, Canada. How far behind am I in the chat? Wow, chat's flying. Okay. Boise, Idaho, getting cold finally. I don't know if it's a good thing or a bad thing. Hot chocolate in Tennessee. Let's see. Devin is in the house. Margarita, 30,000 feet over Iowa. Devin, why are you streaming on an airplane? I think I know where you're going, by the way. I'm sorry I can't join you where you're going. We're Ian for that matter, sadly. We can talk about that a little bit later. Glad to see you, Devin. Glad you're tuning in. Hope you're having a good trip. Southeastern Michigan, it is 35 degrees Fahrenheit here. That seems like warm for Michigan this time of year. I don't know if that's true or not. Chilly in Northeast Texas. Morgan saying, yeah, I got one that does. I mean, I assume printers and 3 that don't. Oh, maybe. San Diego checking in. Sunday at Edmonton, a high minus 26 and a low minus 34. See, that is cold. That is the type of cold that I am not leaving the house. I'm staying exactly where I am. And I can also guarantee you that is the type of cold that will cause the most fights in my house, because that cold gets the reactionary turning of the temperature up in the household to like 75. And then I'm dying of sweat and having to open a window and then getting yelled at for opening a window because I'm letting in cold air, letting out the heat. Sorry, that's a rabbit hole that I just dove down. So it's pretty interesting. Florida's pouring rain. I don't know if you guys heard that or not. if the game is appropriately turned up. I don't know if you caught that, but all of the minis just screamed downstairs, good night, like screamed. So probably scared the hell out of Leo. So, okay. So the minis are off to their bed. Scott's in Manitoba, negative 15 degrees Celsius, 5 degrees Fahrenheit. So it's warm, but it's blizzard. That's freezing cold. I don't know what you're talking about. So everyone's saying good night to the minis. There goes the good night to the minis. Good, because the thing is, the topics we got to cover tonight are not mini related topics. I mean, the 3D printing one is kind of a mini related topic, but the other ones, TikTok, one, I don't want them on TikTok. Two, Diddy litigation, no. Three, Baldoni live litigation, no. So we're not going anywhere while they're still watching the TV. And yeah, it's really weird when you walk past the living room to come downstairs to stream a live stream and you see the thumbnail up on the TV in the living room. So, okay. So, what do you say? Do we want to get into one of our topics? I think we should. Not the Benchy right now, because I can hear them going upstairs, which means that we're in clear. We're in the clear. BMW, thank you for gifting memberships. Very much appreciated. Twumble, another month to enjoy this amazing bunch. Glad to see you here and 5 months in. Thanks for being a member. Melissa Webb, another month with this frenzied bunch. 11 months in. Let's see here, Melissa. Tom Water, Troy. Ta-da. Ta-da, indeed. Lori Webster. Hi, fam. I'm in a chilly Florida, hot tubbing with my wine. Well, you just made a bunch of enemies in the chat. People that are very jealous. Jet J, thanks for becoming a member. Jeanette, rough week. Really happy to see you. Jeanette, I'm sorry it was a rough week. I'm glad I can be here, and hopefully we can chat about some law stuff, take your mind off some of the difficulties of the week. Catherine Fraser, Rob has a rainbow sword. Yeah. It's kind of funny. They make all these really cool filaments. You just kind of buy all of them, and then you end up with a problem. For example, did I purchase 4 new filament reels today? Did I need to? No. Pink, purple, red, and a new white roll. Because I got Valentine's Day coming around the corner. So I got to make little things that are pink, purple, and red for Valentine's Day. See, that's the logic. I'm sticking with it. No one can dissuade me. That was a completely legitimate expenditure of finances, of money. And even if it wasn't, boo-hoo. Baby steps, thanks for remember. Finally, Freed, so glad to see you light up because you made something and feel better having coffee and chocolate stout in Wisconsin. Wow, that's fun. Yeah, making stuff always makes me feel better. I have a lot of fun making stuff. And it does. It brings a whole lot of joy to me. And it helps chill me out and bring me back to relative calm. This week was a week of absolute craziness litigation-wise for me. I've got several trials coming up that are going to have me very, very incommunicado for a little bit of time. And, some of them might resolve, some of them might not. And that's why we have trial. That's why we have court. I could use some live court. It would be interesting. So we'll see. Domestic relations litigation, which is what I practice, tends to be really challenging, especially after the emotionality of the holidays and the kids going back to school. So we deal with what we can. Liz McFall, not ready for near freezing temps in Waco, Texas. Near freezing temps. We've had sub freezing. Cindy Collins, thank you for gifting memberships. Becca has thoughts. Adult toys. Rob, that's how we're starting FNF. No, it wasn't. Whoa, I see what you mean. The comment adult toys. Didn't catch that as I was saying it out loud. Well, can't take it back now. I mean, adult money. There's really no good way of phrasing that. It doesn't come out right, no matter how you want to phrase that. So we're just, big kid toys. I don't know. I guess it was a grave mistake to give someone as irresponsible as me adult money. Horrible mistake. Because now we have Samurai sword. The dog hates that noise. That's so much fun. It is so much fun. So, Jill Moore, need fun after stressed week. Got called back for further tests after my mammogram at the beginning of the month. Now waiting on biopsy results. Prayers that biopsy result comes back negative. You are definitely in our thoughts. That's not a fun, stressful situation. So hopefully everything turns out clear. Mitchell Wirenga, Yellowknife. Where's that? Northwest Territory. What to say that? Negative 35 degrees Celsius. What does that compute to in Fahrenheit? See, the thing is, one of the things that I actually enjoy about the 3D printer stuff is all of the measurements are in millimeters. So it kind of forces you to adjust. Oh, negative 34 is negative 29 Fahrenheit. It forces you to make the adjustment to start thinking in millimeters and actually translate it to inches. So it's been very helpful. So I have enjoyed that part of it. But kilograms to pounds, pounds to kilograms, miles to meters, I am just not going to get there. I wish I could. Probably will at some point. There's already so much reprogramming going of my brain. Baby steps 22. I set my milestone empty. Oh no, I wanted to say we love that you're still a part-time child. You wouldn't be if you were a grown-up all the time. See, that's very kind of you, baby steps. Thank you for sending that and saying that. I agree. I'll enjoy being a part-time child. Laura Christine, thank you for gifting memberships. Mindy FS, I'm an OG since the debt trial. Love you, Rob. 25 months in. Yes, Mindy, you are. Lena H, thanks for being a member for 6 months. Morgan is a member for 26 months. Mindy and Morgan must have joined right at the same time. CS Tears, I know I've been around longer than 10 months. Some people's membership lapses. It's that you guys don't have to shout out how long you've been here. I love having you here every week. If you're a first-time person here, if you've been here for 2 years, hope you enjoy the conversation, the lively conversation and legal debating. Let's toss that to the side so we're not tempted by throwing it around. CS Tears, thank you. Cherry Mills, 2 years of watching your amazing content. Thank you, Cherry Mills. Very kind of you. Charlie Raven, New Year, pink eye and coffee. Oh, no. Oh, hopefully that clears that issue. Jill and Brian W. Snow in Utah outside, vodka inside. Hi, Rob and chat. Hi, Jill and Brian. Hope you're enjoying the warming of the bloodstream with the water of life. Kotri, hello, all still working through last week's FNF, but wanted to thank you and Ian for the laughs that got me through this week. I'm glad that you enjoyed it. Last week went a little off the rails, but it was far better than when I had forgotten to take my ADHD meds 2 weeks ago. That was a terrible decision. We are properly medicated today, though, so all is well. Morgan, does 5 count as multiple? 4 FDM, 1 resin, and yeah, I have a filament and a resin addiction. Morgan, I think 5 is definitely a counting of multiple. 4 FDM printers and a resin printer, that's a whole lot of printing going on in the household. But see, with that logic, you can have 4 things, 5 things printing at one time. And then think of what you could make. I would get shot. I would absolutely get shot if I attempted to have 4 printers in this house. I already have a full shop, which needs organization. No more printers. Maybe 1 more printer. I wonder if she heard that. I don't know. DSN, thank you for gifting memberships for the kids. I don't want to grow up. I'm a Toys R Us kid. I am a Toys R Us kid. However, Toys R Us no longer exists. Oh, actually, for that matter, we can talk about something very simple as well. How many of you crafters like fabric crafts and are in the US and perhaps may have shopped at a certain fabric store called JOANN Fabrics? I imagine there's some of you in the chat who have. Well, JOANN Fabrics filed Chapter 11 bankruptcy this week. So I said this week was interesting because it was. JOANN Fabrics filed Chapter 11 bankruptcy for the second time in 2 years. The first attempt at Chapter 11 was to actually attempt a reorganization. They actually thought they could restructure the company and keep it going and keep it surviving. That fell through. So I think the stats are something like 90% of Chapter 11 plans fail. Most Chapter 11s end in some form of liquidation where the assets get sold or the case gets dismissed and the company just keeps on running out. But the plan for JOANN Fabrics originally failed, and thus they were pressed back down. Now, I think the reason it originally failed and the reason why restructuring failed, based on my review of the case, was that there were a lot of things they were locked into, inventory wise and physical brick and mortar structure wise, things that they were locked into that where they really couldn't reduce the cost side of that balance sheet to get them into a sustainable model. Because anything that they would have had to push out would have been doing massive infrastructure changes to become more of an online platform, but then you're competing with the Amazons of the world. So the second Chapter 11, this one that was just recently filed, they've been rather vocal about coming out and saying that they are looking for a sale of all assets. How does that look? That can be either the sale of basically JOANN Fabrics as a whole. Someone swoops in and buys it, thinking they have a better business model for it, or they sell it off in different piecemeal fashion. So let's say, for example, that you want to buy, I don't know, 28% of the stores, but you want to buy in select markets. You can do that in the Chapter 11 case. They'd put together a proposal for the sale, and then you would say, I want to buy 28 stores in the greater Washington, D.C. area. The trustee balances it, the judge weighs it, and the judge says, I hereby declare that you have purchased these stores. Creditor's going to buy out, then some of the remaining stores will close. Or let's say, for example, someone comes in with a high dollar bid and says, I want to buy 100% of the inventory, but I don't want any of the liabilities. Okay. Let's say they want to buy the software, the infrastructure. Okay. So that's what we're looking at is JOANN Fabrics is liquidating, but people think of liquidating and they think of it in a strange fashion. People think of liquidating, they think that all the stores are going to physically close immediately. It's not really what happens. So they're going to look for buyers. Obviously, the easiest and the most economical way for the Chapter 11 trustee to manage it or for the bankruptcy to manage it is a buyer comes in and intends to buy whole markets of these operating stores. And they just assume the liabilities the store has, purchases, and go forwards and operates. That's the easiest, but we'll have to see what JOANN Fabrics does. I know that didn't really come as a major surprise other than to see that, hey, you tried to reorganize, you failed, now you're back and you're liquidating. So it's not really a shock. They did announce that they're going to continue to operate and keep the stores open while they're waiting and seeking out a potential buyer. So you're not going to have all your fabric supplies cut off yet. But it might be a good time to start looking around for those deals. That was the news. I thought it could use a brief mention. Just because, thank you for gifting memberships. As one, happy Friday, all. Happy Friday to you. I love pie. Oh my God, 11 months. Definitely been watching longer. It's fine. It's not a challenge, not a test. E. Warner, get in the car. Elizabeth has been a member for 27 months. It's quite a long membership run. Just because I now officially have less than 52 weeks left in my 30s. Wish me luck. Absolutely good luck in that regard. 40s aren't bad. 40s, you can still have just as much fun in your 40s as you can in your 30s. I'm living proof. Holly's hobbies, horrible. It was funny as hell. I think that was in relation to the 3D printed stupidity. Nancy Drubby, Rob, we need a Leo swoop. Who's with me? I got to get Leo to sit still for long enough to make a swoop. I think I could probably do that. He heard me say his name. I can't see him at the top of the stairs, but I can hear him. He's wandering around while the kiddos are getting in bed. Luna C, big week, turned 48 and became first-time homeowner today. Now to move from Seattle to Houston with 2 dogs and 2 cats. Congratulations. That is definitely worth and warranting remarkable celebration. You should pop some champagne and enjoy yourself. First-time homeownership is a lot of fun. It's a lot of challenges. It's a lot of fun. The Aurora H. White. Been here since depth, thanks to finding you, EDB, Runkle, and more. I started a whole new venture that I never thought I could before. Thanks all. That makes me very happy to read. I always love reading those when you guys get stuff started and have some fun doing that. Always enjoy that. People following and pursuing things. Crazy by proxy evening, all evening to you. So, what do we think? Conacy is suggesting the dog moving at the speed of light is a swoop. That'd be a really fast swoop. Video swoop like Runkle. I could do that. I just got to film Leo doing something. I feel like I got to have him do a trick, though. The only trick he knows is be crazy. No, he knows a lot of tricks. He can do a lot of fun. Yes, Big Lots is also closing as well. They're restructuring. I think they're actually going into liquidation as well. A lot of stores, man. They put them through the COVID challenge. A lot of them limped through that, thought they were going to be able to come back, were heavily leveraged. And at this point in time, the money has just quite simply run out. It's just run out. Not to mention staffing concerns, price of materials, inflation, all the above. Pretty wild. Adrian Angevine, JOANN has the best fabric, but the local managers were the worst. Get rid of them. I'd buy there again. He used to spend $250 a month until 5 years ago. Wow. Interesting. Is there a local shop you went to from there? I imagine you kind of have to. Because the big box stores, you're not going to get all the fabrics you need, like the Michaels. You might get some. Probably some specialized distributors. All right. So, first things first, we're going to talk about the Supreme Court. So, let's go ahead and swoop to that and actually go and talk about some law stuff. So, swoop. So, for those of you guys who were listening in last week, we listened to the Supreme Court coverage. The Supreme Court took on the case of TikTok, the potential ban that TikTok faced if ByteDance did not divest of ownership of TikTok. And had a friend on, Kurt, on Civil Law, joined us for that discussion. It was a great conversation. Went through and listened to the oral argument. And go figure, in the very beginning of the oral argument, the lawyer that was advancing TikTok's position just seemed like he just did not have his footing. To the point where about halfway through the questions to that particular lawyer, Kurt and I both gave our opinion that it would be a 9-0 opinion by the court, allowing the ban to go into effect. And lo and behold, we have a 9-0 opinion. Now, I haven't read it all the way, so we're actually going to read it here on stream because I want to see how they reach their conclusion. I don't think there's a dissent. I think there's several concurring opinions, but let's see what the logic was. Shall we? Share the window. Okay. So in the Supreme Court of the United States, TikTok Incorporated et al., the petitioners versus Merrick B. Garland, the Attorney General, and then Brian Firebraw, petitioners against Merrick B. Garland, Attorney General. So consolidated cases. As of January 19th, the Protecting Americans from Foreign Adversary Controlled Applications Act, PAFACA, Protecting Americans from Foreign Adversary Controlled Applications Act, PAFACA. We're just going to call it PAFACA. So PAFACA will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless U.S. operation of the platform is severed from Chinese control. Petitioners are two TikTok operating entities and a group of U.S. TikTok users. We consider whether the act, as applied to petitioners, violates the First Amendment. So, question, does it violate the First Amendment? In doing so, we are conscious that the cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter Advised 80 years ago in considering the application of established legal rules to the totally new problems raised by the airplane and radio, we should take care not to embarrass the future. What a cool quote. Don't embarrass the future. That caution is heightened in these cases given the expedited time allowed for our consideration. Ah. So, right here, tip of the hand. We are looking very narrowly at whether this can be upheld. I believe this is on a temporary basis. I don't know if they're going to reach the actual merits based on this. We shall see. Hey, can I get this a little bit larger? Just a bit. Oh, too big. Nope, just big enough. TikTok is a social media platform that allows users to create, publish, view, share, and interact with short videos, overlaid with audio and text. Since its launch in 2017, the platform has accumulated over 170 million users in the United States and more than 1 billion worldwide. Elfligans, have you not met teenagers? The future is absolutely embarrassed by their parents. I don't care. I live to embarrass these kids. We're just going to go with it. Ryan Matt Wagner, who's with me, every SCOTUS decision that isn't 9-0 should go into a queue to be reviewed by the court. I think that's sarcastic. 70% of these cases, guys, come out 9-0 or like 8-1. Since its launch, we already talked about that. In 2023, US TikTok users uploaded more than 5.5 billion videos, which were in turn viewed by more than 13 trillion times around the world. Opening the TikTok application brings a user to the For You page. Side note, I always love when judges, including Supreme Court judges, have to find a way to, properly say these things, where they have to articulate these applications and what they do and the various features of the applications in legal jargon, right? So a For You page, say it in common parlance, everyone knows what it is. It's like, now, what would you have to do if a judge had to address within their pleadings that's cap, or some other phrase that kids use? I don't know. No, what was it? One of the kids used the other day? Oh my God, they said that's so Ohio. I've never heard that in my, well, apparently it means boring. I am just saying what the kiddos do these days. So, anyways, back to the discussion at hand. Opening the TikTok application brings the user to the For You page, a personalized content feed tailored to the person's interests. TikTok generates the feed using a proprietary algorithm that recommends videos to a user based on the user's interactions with the platform. Each interaction a user has on TikTok, idiot, TikTok, has on TikTok, whether it's watching a video, following an account, leaving a comment. Actually, I think it's more pervasive than that. The court chose like the 3 easiest things. Watching a video. TikTok tracks how long you watch the video, and they factor that length and duration of your watch time into what other content to recommend to you. TikTok apparently monitors where you're looking at the screen. TikTok monitors a lot of stuff when you're focused on the video or not focused on the video. So it's more than just watching the video, following an account, or leaving a comment, but it enables the recommendation system to further tailor a personalized content feed. A TikTok user's content feed is also shaped by content moderation and filtered decisions. So this is the pushed content. TikTok uses automated and human processes to remove content that violates the platform's community guidelines. TikTok also promotes or demotes certain content to advance its business objectives and other goals. That's going to come up again. TikTok is operated in the United States by TikTok Incorporated, an American company incorporated and headquartered in California. The ultimate parent company is ByteDance Limited, a privately held company that has operations in China. ByteDance Limited owns TikTok's proprietary algorithm. So basically, what is TikTok without the algorithm? Is TikTok US anything without that algorithm? No, it's not. Which is developed and maintained in China. The company is also responsible for developing portions of the source code that runs the TikTok platform. ByteDance Limited is subject to Chinese laws that require it to, and this part's relevant, assist or cooperate with the Chinese government's intelligence work and to ensure that the Chinese government has the power to access and control private data. That is a problem and something that very many people are not talking about. So, in recent years, U.S. government officials have taken repeated actions to address national security concerns regarding the relationship between China and TikTok. In August of 2020, President Trump issued an executive order finding that the spread of the United States of a mobile application developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States. So, this executive order in 2020 determined that TikTok raised particular concerns, noting that the platform, quote, automatically captures vast swaths of information from its users, end quote, and is susceptible to being used to further the interests of the Chinese government. The president invoked his authority under the International Emergency Powers Act, Economic Powers Act, and the National Emergencies Act to prohibit certain transactions involving ByteDance or its subsidiaries, as identified by the Secretary of Commerce. The Secretary published a list of prohibited transactions in September of 2020. But federal courts enjoined the prohibitions before they took effect, basically saying you can't do that by executive order. Good. I don't like things by executive order. Just days after issuing his initial executive order, President Trump ordered ByteDance to divest all interest and rights in any property used to enable or support ByteDance's operation of the TikTok application in the United States, along with any data obtained or derived from the United States. So that was what they wanted to do. So get rid of all of this data. ByteDance filed suit in DC Circuit challenging the constitutionality. In February 2021, DC Circuit placed the case in abeyance, means chill out, to permit the Biden administration to review the matter and to enable the parties to negotiate a non-divestiture remedy that would address the government's national security concerns. So here's what that means. Everyone chill out. We're not going to let this go into effect. Not going into effect. The administration is going to review and determine what we're going to do. You guys negotiate peacefully, see if there's a way out of this that doesn't involve litigation. Throughout 2021 and 2022, they negotiated with executive branch officials to develop a national security agreement that would resolve those concerns. The executive branch officials ultimately determined, however, that the proposed agreement did not adequately mitigate the risks posed to U.S. national security interests. The negotiations stalled, and the parties never finalized an agreement. Against this backdrop, so that's the context. No agreement reached. Executive action likely unconstitutional. What are we going to do? In steps Congress, and actually does something that Congress is supposed to do, which is legislate. So Congress jumps in and they pass PAPACA. The act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary-controlled application in the U.S. If they violate the prohibition, they're subject to civil enforcement actions and hefty monetary penalties, which means if they have assets in the country, those assets become seized to pay penalties. Looks like Steve. Hey, Steve. Glad to see you here, my friend. We've got the tiki-taki on the live screen. Terry Burrell. One of the questions that was being asked, why, if you don't want, that was the question that was being portrayed by the media, that's still being advanced by the media, which is still very concerning to me, is basically saying the U.S. government's coming in and censoring everybody, and they're saying everyone shut down. We're going to shut down the speech. We're going to shut it down. No, they didn't. They said, if you're going to operate, can't have the Chinese ownership. Okay. As a consequence of that decision, they can choose to shut it down, or they can sell it if it's palatable, or they can sell part of it. They had to divest. So the act provides two means by which an application may be designated a foreign adversary controlled application. First, it actually goes in and expressly designates ByteDance. So it actually goes and says if it's operated, directed directly or indirectly by ByteDance Limited. Pretty interesting. And yeah, I've seen some of the chats that there's already a bunch of these new applications that all these people are flocking to, which are probably going to be violative of this act anyways. It's just, it's a mess. Second, the act establishes a general designation framework. So it says, here's how you can basically designate one of these companies to be a naughty company. If it's operated by a covered company that's controlled by a foreign adversary, and B, determined by the president to present a significant threat to the national security of the United States following public notice. So they basically defer and they give some executive the authority to implement this and some rulemaking power. In broad terms, the act defines covered company to include a company that operates an application that enables users to generate, share, and view content and has more than 1 million monthly active users. I would say that's an appropriate use of the congressional Commerce Clause power. Unless all those users are in one state. I don't know. Even so, that would impact. The act excludes from that definition a company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information reviews. So if your sole purpose isn't a lot of this, news related content or dancing around like idiots, if you're just posting reviews, you can do that. Imagine an application that just did that. How freaking boring would be that? That would be horrible. Just all you see on your For You page is review after review after review. Ugh. The act's prohibitions take effect 270 days after an application is designated by a foreign adversary controlled application. So 270 days. So they had a time frame within which to comply. Here we go. The act exempts a foreign adversary controlled application from the prohibitions if the application undergoes a quote qualified divestiture. Now, what the heck is qualified divestiture? It's a good thing it defines it because Congress is so good at that. Always so good at picking out and defining things. Was I checking email? Yes. Bad ADHD. Focus. A qualified divestiture is one that the president determines will result in the application no longer being controlled by a foreign adversary. Well, that seems like a whole lot of deferential power. Seriously? Why not give it to the damn FCC? I don't know. That seems kind of strange to me. Really, I want to look at this act. What is it in law? What's the code section of this stupid thing? Let me say it that way. Where is it? No, give me the lead in. Oh, it's annoying. Hang on. Let's just see. Pafaka. Why am I saying that like Mufasa? Because it sounds like Mufasa. Pafaka. Protecting Americans. And when you phrase a piece of legislation like that, doesn't it sound overly protectionist? Just as it is. Just I don't like how it's phrased, but here's a codification. 15 USC 9901. Copy. Paste and search. Prohibition. Definitions. Exclusion. Data broker. Precise identifier sensitive information. Precise geolocation information. Now they go through and they really do a good job of defining what sensitive data is. So I will give them that. The effective date. I'm looking for what's part of this. Section 2C1, Section 2, Part C, Section 1. Blah, 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 shall cease to apply. Exemptions for qualified divestitures. Oh, 2G6A. If you ever wonder why lawyers go crazy, it's because of all of this, because you have multiple definition sections within the same damn statute. G6A. It really does say this. Qualified divestiture. The term qualified divestiture means a divestiture or similar transaction that A, the president determines through an interagency process. Interagency process that would result in the relevant foreign adversary controlled application no longer being controlled by a foreign adversary. So it contemplates some executive agency action. Did they designate an agency? This all seems rather vague. Oh, there's a delegation of authority. Okay. Delegate to Attorney General. Yeah, okay. There, yeah. There's a designated committee for review. All right, so there you go. The designated committee for review is Secretary of State, Secretary of Treasury, Secretary of Defense, Attorney General, Secretary of Commerce, Secretary of Homeland Security, Director of National Intelligence. Okay, so they actually designated an actual, that's the interagency cooperation. All right, that passes the smell test. Now that we've passed the smell test, President must further determine that the divestiture precludes the establishment or maintenance of any operational relationship between the United States operations and the application and any formerly affiliated entities that are controlled by a foreign adversary, including any cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. Two things: content recommendation algorithm or agreement with respect to data sharing. Algorithmic recommendations are going to become more and more a thing. We're going to be litigating this issue for quite some time. And honestly, I think this is one of the first times you're going to see this, because I think it's going to come up a lot more. You've seen them try to litigate it in the context of Google's algorithm, and that's was section 109? No, not 109. I think the immunity, the broadcaster, the common platform immunity. You're going to see this coming up a lot. Now, what's interesting about that is what Google argued when they were sued. Section 230, yes, Section 230. What Google argued when they were sued was that they were themselves not the creator of the content. Right. So let's talk about this for a second. This is kind of interesting. I'm very fascinated by this. When Google got sued, they relied heavily on Section 230, and in doing so, they made the statement that they themselves were not the creator of the content. That the person responsible was the actual creator, the person who actually put that content out there. However, Google has a certain algorithm, right? When one video, and by Google, I mean YouTube, so Alphabet. So when one video ends, you get a recommendation of the next video you want to see. Sometimes the creator gets to say what you get to see at the end screen, but sometimes if they leave it blank, then YouTube fills in the blank. YouTube also has a start page where you jump in there and it has suggestions of videos that you might like to watch given your past viewership and engagement. So Google, when Google was being sued, said, this ain't our speech. This is the individual creators. You can't sue us. We're a common platform. TikTok actually comes in and makes the exact opposite argument. TikTok comes in this case, and makes the First Amendment argument. And they say, we are protected because the algorithm and the features that algorithm recommends is an expression. It's actually a speech. It's us, TikTok, engaging in speech by recommendation of content. I used the composer analogy last week when I talked about it. When you have a composer standing in front of an orchestra, or the conductor rather, who's conducting a symphony and directing all the various parts of the orchestra, who are you hearing? Who is the speaker at that point in time? Yes, each one of those individual instruments is speaking, but also the conductor is, because the conductor is the one who's orchestrating and telling them all to, in combination, what you end up hearing. That's the person who creates the beautiful sound that comes, beautiful or horrible, depending on where you are, what you hear. So TikTok said our algorithm, what we have put together is us speaking. That was the argument being made, which is the exact opposite of what Google has relied on in 230. And it brings up a really interesting question about how we're going to look at this going forward. Because I imagine you are going to see a whole lot more companies, several more companies relying on this type of argument. Because if Section 230 immunity goes away, that's where they're going to go. They're going to say it's our protected speech. Based on how that argument, based on the logic behind that, I actually am inclined to agree with it. So I thought it was very fascinating. But anyway, two different arguments being made. Little sidetrack. So ByteDance and TikTok, along with two sets of users and creators, filed petitions for review in the DC Circuit Court challenging the constitutionality of the act. As relevant here, the petitioners argued that the act's prohibitions, so TikTok-specific foreign adversary-controlled application designation, and the divestiture requirement violate the First Amendment. So by telling us that we are designated as this bad person and can no longer do it, and by asking that we divest our ownership interest, or divest, yes, okay, you are violating our First Amendment protections. The DC Circuit Court, or DC Circuit, consolidated and denied the petitions, holding that the act does not violate the First Amendment rights. I forgot to highlight, sorry. After first concluding that the act was subject to heightened scrutiny under the First Amendment, well, that's a tip of the hat. The Supreme Court saying, no, you did bad. After first concluding that the act was subject to heightened scrutiny under the First Amendment, the court assumed, without deciding, that strict rather than intermediate scrutiny applied. So the court basically says, we're going to assume the highest standard, assume strict scrutiny. The court held that the act satisfied that standard, finding that the government's national security justifications, countering China's data collection and covert content manipulation efforts, were compelling, and that the act was narrowly tailored to further those interests. The concurrence in that ruling, I'm not going to pronounce that name. For those of you thinking that I was going to try and pronounce that name, no. And now that I say it out loud, I'm sitting here trying to pronounce the name in my head. The chief judge. The chief judge, writing in concurrence, in his view, the act was subject to intermediate scrutiny and was constitutional under that standard. All right, so which level of scrutiny are we applying here? We granted cert to decide whether the act as applied to petitioners violates the First Amendment. All right. So is it a violation as applied? As applied, right? It's an as applied challenge. Yes, as applied. At the threshold, we consider whether the challenge provisions are subject to First Amendment scrutiny. Do you fall under the First Amendment? Is the First Amendment even applicable here? Interesting. Laws that directly regulate expressive conduct can, but not necessarily, trigger that review. We've also applied First Amendment scrutiny in cases involving governmental regulation of conduct that has expressive element. Wearing of armbands, or engaging in certain behaviors like sitting down in a crowded restaurant and refusing to leave. and to some statutes with which, although, or by the way, spending money on a campaign or spending money in advancing a campaign. These are expressive actions, not simply speech. And to some statutes which, although directed at activity with no expressive component, interpose a disproportionate burden on those engaged in protected activity. Okay. So even though what you're doing is not expressive in nature, the burden that is felt only by those individuals who are expressing, engaged in First Amendment activity. For example, shut down this book distributor, and the ramifications are, well, everyone affected by those are speakers. It's not clear the act itself directly regulates protected expressive activity or conduct with an expressive component. Indeed, it does not regulate the creator petitioner at all. All right. So it doesn't regulate you guys, creators. It directly regulates ByteDance, and TikTok only through the divestiture requirement. So it doesn't actually say the type of speech that you're engaged in is one of the precursors. It says just ownership. That's it. Petitioners, for their part, have not identified any case in which this court has treated a regulation of corporate control as a direct regulation of expressive activity or semi-expressive conduct. Yeah, you remember this part of the oral argument. It was uncomfortable. It was very uncomfortable. Let me see. To do expressive content, expressions, expressions, expressions. Finding the transcript. Here we go. Because I think I can see. Come with me, and you'll be in a world of protracted litigation. In this world, we can see one side getting annihilated. If you want to withstand scrutiny, you have got to demonstrate certain government interests and tailoring. Where are we? Because I want to find this question. We hesitate to break that new ground in this unique case. The hesitation is felt, justices. It is remarkably palatable. Your hesitation to break new ground all the time. SupremeCourt.gov, where they actually have the transcript created and page numbered, because pin sites are helpful. Page 37 to 40. Who's asking the question? 37 to 40. Come on, is this Roberts? Did Roberts write this? If this is Roberts' opinion, oh my God, hang on. I gotta fast forward because this is gonna be kind of annoying and kind of frustrating, but I get it. Who It's per curiam. So yeah, Roberts wrote it. Did he toot his own horn? Damn. Roberts doesn't usually write this long. Yeah, I'm pretty sure this was Roberts. Sotomayor concurred. Who joined her? Just one. Who else concurred? Gorsuch concurred. Leo has very strong opinions. Oh, so you had two concurring opinions. Unanimous court. It's Roberts. Kurt, it's Roberts. I'm telling you it's Roberts, and I'll tell you why it's Roberts. Because this little part of the oral argument he cites to, let me play it. Suppose New York State passes a law. Let me see. I can actually look at this. We are, what, 38 through 98? Take this down real quick. Stop screen. Here. This is why I can tell that Roberts wrote it.
Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building.
You should be hearing this.
And they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we think that's the minimum that should be done here.
Thank you, counsel. We've been talking about connection between the regulation.
Now you're gonna now we're within the even under direct
TikTok
questioning
and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform. That's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent.
All right. So, based on that colloquy and who found themselves at the forefront of that colloquy and who then cited their own colloquy in their own opinion and their own questioning in their own opinion, does that give you a hint as to, who might have been responsible for that opinion? I think it gave me a hint. That's how I gathered. So Roberts just loves citing himself. Okay. So it's kind of funny to me that the justice that's so heavily focused on the reputation of the court and the reputational history of the court, the justice that's so heavily focused on the reputation of the court cites his own questions. I don't know. Kurt, you're a Roberts fan. You love Justice Roberts, Chief Justice Roberts. I know that he is your favorite jurist of all time.
No.
I traumatized you just on that one topic.
No, I like Gorsuch.
Yeah. But his him citing his own question, his own transcript of his own question.
Yeah. Well, why not?
Totally a Roberts move. So essentially, here's where we're at. We are still relatively early on in the opinion. I imagine you've read this thing ad nauseum already.
I did.
And it seems to me that the court is already, one, skeptical of the argument advanced by TikTok, and two, very hesitant to go much further than just saying, maybe we're going to uphold this. Did they even get to the scrutiny question?
Yeah.
Oh, good.
On the First Amendment issue? Yeah.
Okay. So let's see. In any event, petitioner's argument more closely approximates claim that the Act's prohibitions, TikTok-specific designation and divestiture requirement, impose a disproportionate burden on their First Amendment protected activities. So not a direct regulation, but as applied. Government doesn't contest that because it's commercially infeasible for TikTok to be divested within the 200.
I think that's a lie.
That's
also, I'm not sure 270 days is the real measure because this has been ongoing for 4 years. Also, I think it's a lie.
I don't know if the government didn't contest that. I didn't hear them raise it in the argument, but I don't think the question was asked, and I don't think it really comes down. So the act effectively bans TikTok in the United States. This is contrary to what he wrote earlier. All right. We've recognized a number of these asserted First Amendment interests. Blah, blah, blah. Okay. Got citations. Association for purpose of speaking, which was what I kind of viewed, the association. Express content by association. Effective ban on a social media platform with 170 million US users certainly burdens those users' expressive activities in a non-trivial way. I'm not following his logic here. I don't think I agree with the effective ban part.
No, I don't think that that's correct either.
Does that get addressed in one of the concurrences?
Not really, no.
Interesting. So they just kind of concede the point. It seems like a concession more than anything else. At the same time, a law targeting a foreign adversary's control over a communication platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. All right, so we're saying it's a different type of...
Yeah, I feel like that sentence is way underselling the proposition. That sentence to me is like on the one hand, but on the other hand, to me, these are wildly different. So I think that's underselling the distinction
he ran away so far from this point. So he makes this point here, right? This sentence that basically says, we're going to draw a distinction. The law targeting adversaries' control is in many ways different in kind from the regulations of non-expressive activity that we've subjected to scrutiny. Okay, there's that. But didn't he just cite that they can't point to a single instance when we've talked about control as being regulation on speech? Never having decided that? Yeah. Those differences, the acts focus on a foreign government and the congressionally determined adversarial relationship between the foreign government and the United States. The causal steps between the regulation and the alleged burden on protected speech may impact whether First Amendment scrutiny applies. So we're not even at the framework of does scrutiny apply yet. Of course, not articulated a clear framework for determining whether regulation of non-expressive activity that, holy crap, that's a sentence. Okay, this court has not articulated a clear framework for determining whether a regulation of non-expressive activity, so you're not doing something that expresses speech or it's speech related, but it disproportionately burdens those engaged in expressive activity, triggers heightened review. So rather than rational basis, which rational basis review is the lowest thing, basically says if you have a rational, if you determine that this is a rational or rationally required to meet some end, legitimate end, you win. If you fail rational basis, you're an idiot. Intermediate scrutiny.
Yeah, and normally rational basis is the bottom of the pyramid, but when it comes to foreign governments, I'm not even sure you need that much. I think our whims, arbitrary and capricious, will probably be fine because it's in the nature of foreign relations.
And it's inherent in the sovereign to make those decisions.
Yeah.
Right?
Right.
We need not do so here. All right. This is another fucking problem I have with Roberts. I'm sorry.
You have a problem with your favorite justice?
Everything he says is dicta. Do you remember the Affordable Care Act where he wrote how many pages of an opinion? And at the end of it said savings clause?
Yeah. I remember it because I was there when he announced it from the bench. That's why I remember it.
You know why that's so frustrating? Because basically everything that I read in the preceding 3 pages is irrelevant.
Yeah. I remember that.
It's like a teacher that requires you to read a homework assignment and then doesn't offer a quiz or a test on it. Oh, so stupid. So, the court hasn't articulated this. So it also, here's the other thing that pisses me off about it, is it very much seems to encourage additional litigation. It very much says this is an avenue that you might want to pursue, folks, and try to bring this issue up in the future, even though it wasn't raised here and it's not something they were getting to. Why are you trying to tip your hand? Why are you tipping your hand? We assume without deciding that the challenge provisions.
Maybe the Supreme Court doesn't have enough pending cases. Maybe they're desperate for work.
Oh yeah, I'm sure that's the case. Their docket is insane. Past few terms, they've taken more cases than they usually have.
Well, it depends by what you mean by usually, because from historical standards, they're still like way down.
They are, but he's given more time. And the problem is the oral argument times expanding is giving you more insight into the court, but it's also cutting down the number of cases they can hear. So whereas arguments used to be capped at 1 hour, 30 minutes aside, now they're going on for 3 hours. So
yeah, we're going back old school, uncapped. Before too long, we'll go real old school, and arguments will take multiple days.
Oh my God, could you imagine that? Oof. No way. At the heart of the First Amendment lies the principle that each person should decide for himself or herself the ideas and beliefs deserving of expression, consideration, and adherence. Turner 1, actually. Government action that suppresses speech because of its message contravenes that essential right. Oh, we're going to go through the whole analysis, aren't we? We're going to do, okay. Content-based laws, those that target speech based on its communicative content. So if you're looking at the content and actually regulating it, this reminds me of a Breyer opinion or a Breyer hypothetical. Oh my God. Were you with me when we listened to the one where they were talking about the kale stand? Justice Breyer, he was like, let's assume that I operate a kale stand and I have a sign that says kale sold here. Never mind. That's my brain. It's going sideways. So are you looking at the content to regulate it?
I've done a lot of very deep work trying to get rid of Justice Breyer's question hypotheticals from my brain.
There were some that made me laugh, but a lot of them were just horrible. They took 15 minutes to relay. They're presumptively constitutional. So if it's looking at the content of the speech to determine whether it's regulated or not, if it's saying, if the speech says A, it's regulated. If the speech says B, it's safe. If it's looking at the content, it's presumptively unconstitutional. And it's justified only if it proves narrowly tailored to serve compelling state interests. So that's strict scrutiny standard. Content neutral laws, so basically just says can't speak here, they're subject to intermediate level of scrutiny, because in most cases they pose a less substantial risk of exercising certain ideas or excising certain ideas or viewpoints from the public dialogue. So these are time, place, and manner restrictions. Under that standard, we will sustain a content neutral law if it advances important government interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. Time, place, and manner, you can protest here from the hours of noon until 6 p.m. Because it is otherwise a very heavily trafficked area. That's the justification. We giving you time. We're giving you.
You can't protest out someone's home. You can't use sound amplification equipment.
Yeah, that kind of stuff. Time, place, manner. Two forms of content-based speech regulation. First, a law is content-based on its face if it applies to particular speech because of the topic discussed or the idea or message expressed. For example, basically, if you said you can't talk about can't talk about mental health, right? If you're identifying an entire category of speech that you can't engage in, then yeah, you're directing a particular topic. Second, facially content neutral law. So we're not telling you what you can or cannot say is nonetheless treated as content-based regulation of speech if it cannot be justified without reference to the content of the regulated speech. So you have to actually go into the content to determine whether or not it is regulated.
Yeah. But then see for contrast, City of Austin, which says basically the exact opposite of that.
I remember the case that I was remembering was a Breyer hypothetical, because one of the challenges they raised a First Amendment issue because the billboard that said the name of an establishment, they raised a First Amendment claim. They said, this is protected First Amendment speech. You can't regulate what my billboard says when it says the name of an establishment. And the attorney was making the argument that says, well, you have to read it, so it's inherently content-based.
Yeah, that's City of Austin.
Is that City of Austin?
Well, City of Austin was dealing with on-location versus off-location signs.
Yes, that was the case.
But how do you know if a sign's on location?
Because you have to read it.
Yeah,
because you have to read the sign.
But the U.S. Supreme Court said that's not content-based. That's why I say see by contrast City of Austin, because apparently you can justify it with reference to the speech without it being about the speech. Yeah.
Anyways, we get loopy. As applied to petitioners, the challenge provisions are facially content neutral and are justified by content neutral rationale. Challenge provisions are facially content neutral. Yeah, is anyone disputing that? No, wait, they tried to dispute that. They failed terribly in disputing that. It's regulation against a company. Everyone is harmed by it. All the speakers on this platform, it's applied equally. So no, it's content neutral. Do we need to read that? No, we don't need to read that. Oh, they argue that the act is content based on its face because it excludes from the definition of covered company any company that operates an application whose primary purpose is to allow users to post product reviews. Come on. Again, we don't need to decide whether it's content based. This is the other thing. Why are we having the discussion? Justice Roberts, if you say we don't need to decide based on this, why don't you just get to the freaking point? Make your point. Don't go through this long dialogue and say, we don't have to get here. We don't have to get here. We don't have to get here.
Then don't, right?
Yeah, don't do it. Because all of this is dicta. The problem is dicta has a big impact in how cases get litigated in the circuit courts below. Because these are parts of the opinion that, while not controlling, means that this decision was not based on any of these factors. They're recitations of opinion on uncontrolling law. These are not controlling. But every circuit court judge is out there looking at it going, I'm going to rely on this piece of language because it helps the way I want the case to be ruled upon. So don't do it. The question before the court is whether the act violates the First Amendment as applied to petitioners. To answer that question, we look to the provisions of the act that give rise to the effective ban that petitioners argue burdens their First Amendment rights, the exclusion for certain review platforms. However, applies only to the general framework for designating applications controlled by covered companies, not to the TikTok specific designation. As such, the exclusion, oh, we're not talking about the exclusion. Okay, fine. Then just tell me we're not talking about it. Government supports the challenge provision with content neutral justification, preventing China from collecting vast amounts of sensitive data from 170 million US users. Yep.
Yeah.
Seems to me that that's a legitimate government function and purpose. It neither references the content of the speech nor reflects disagreement with the message that the speech conveys. Stop collecting our data. Okay. The Act's TikTok specific distinctions do not trigger strict scrutiny. If you identify it based on the speaker, or all too often simply means to control content. Citizens United versus Federal Election Commission. For that reason, regulations that discriminate among media or among different speakers within a single medium often present serious First Amendment concerns. If you basically passed a law that said, hypothetically speaking, MSNBC shall not broadcast, you're designating a speaker. You are really walking right into heightened scrutiny. But while laws favoring some speakers over others demand strict scrutiny when the legislature's speech or speaker preference reflects a content preference. See, that's what I was saying. If you chose like MSNBC or Fox News, you're expressing a content preference. We all know it. We just don't talk about it. But while law, blah, 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 such scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated. Fox News, you shall not speak because you are owned by the Chinese Communist Party. Divest ownership. Then you can start speaking. Okay, got it. Understood. I'm with you, Roberts. For the reasons we've explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing the sensitive data of 170 million US TikTok users is not a subtle means of exercising a content preference. Yeah, it's just stop collecting data. And in order to make you do that, if you have to shut down your platform, we're making you shut down your platform. Okay. So that's the data collection argument, which they talked about for maybe 10% of the oral argument. So it seems like they're going to uphold it on data collection. No strict scrutiny, only intermediate scrutiny. Okay. Act satisfies intermediate scrutiny. Well, the second you said no strict scrutiny, the district court already said it satisfies strict. You're screwed. Challenge provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest. Okay. 3. Footnote. Ooh. That's fun. Our holding is based only on public record without reference to the classified evidence the government filed below. That's a subtle hint that says if we had to go further, I imagine we'd have even more to justify this. The Act's prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance to capture the personal data of U.S. TikTok users. This objective qualifies as an important governmental interest under intermediate scrutiny. Oh, satisfies strict scrutiny. Collects expressive personal information from or about its users. We all know this, the public reporting. This is why the House record was important.
Yeah, they're trying to collect all the things. Contact data, user data, keyboard data, camera data, location data.
Everything.
All the
transportation data, not just location data, but it's actually mapping where you were going, time from like to and from. Yeah, see? This people when you look at these devices that you have,
yeah,
when you log into an app and the app says
these things are great. Tell like a paranoid guy from the 1950s about these guy things, right?
Exactly.
Someday they're gonna put a device on you, man. It's gonna track you everywhere you go.
It's gonna track everything you do. You sit there going, no, take off the tinfoil hat. There's no way. Yeah. Okay.
You'll know you better than you know yourself.
Yeah, exactly. If, for example, a user allows, so when you get those little permissions requests, right? When you're in an application, the application says, we would like to access your contacts. Would you like to give us that contact information? You might think, rather innocently, that it's just going in there looking at names and matching up email addresses to see if there's any other users on its platform that you might be able to match with, right? Let's face it. We've all done it. Everyone. I don't care how security conscious you are. You have logged into an app and the app has said, would you like to sync your contacts? And you're like, yeah, I don't want to repeat all that stuff. I don't want to retype all that crap. Sync my contacts. Here's the problem. When you're syncing the contacts with a company that's located in the United States, that company that's located within the United States is subject to United States data protection laws and regulations, right? So they have to engage in certain behaviors and acts to protect your consumer data. This is why also when we talk about laws that regulate consumer data, it's really important that we actually talk about what the regulations allow and disallow, rather than just say social media companies bad. Now, hypothetically speaking, let's say that data gets shipped off to somebody who's not subject to US laws or regulations as to how they can use that data. And the data isn't just the email addresses, but it's the birthday. It's the profile photo. It's the other photos that you have tagged to that user. It's the communication history. It's all of it. Now they're not subject to US laws that govern the dissemination or use of that data. And instead, it allows, as is put here, China to track the locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage. Not just that, but the Chinese law actually allows and requires the company to do the bidding of the intelligence sections of the Chinese government. So literally, and the thing is, when is the company going to disclose that to you? Seriously, they probably have a direct damn pipeline. And here's another hint that they're going to lose their argument. Rather than meaningfully dispute the scope of the data collection TikTok collects, or the ends to which it may be used, they contest the probability, asserting that it's unlikely that China would compel TikTok to turn over user data for intelligence gathering purposes, since China has more effective and efficient means of obtaining relevant information. Are you out of your damn mind? What's a more efficient means than having someone give the information to you? Okay. Government's TikTok-related data collection concerns do not exist in isolation. The record reflects that China has engaged in extensive and years-long efforts to accumulate structured data sets, in particular on U.S. persons. Yep. CrowdStrike hack. What was the other one? There was CrowdStrike, OPM, right?
OPM was a big
They were
one.
hacked.
The Defense Department.
DOD, yep. And the hacks are looking specifically for these data sets. So when this argument, this contention is made, well, the government clearly has easier means of doing it. You mean like trying to hack into these institutions when instead they can just go to the company that is under their control and say, give it to me, please. And they get it. I mean, yeah, AT&T was one. Even if they haven't leveraged it. I mean, that's the thing is, and all of this, let's say that people are still looking at you saying, well, this is crazy for you to suggest that they might actually do this. I don't care. The possibility of them doing it makes it a compelling governmental interest. If it's possible, and you can contemplate the negative ramifications of what would occur if it did happen, wouldn't you say the government has a pretty compelling interest in making sure it doesn't? Sounds logical to me. All right. Government's informed judgment, substantial respect. Yeah, we knew you were going to defer there because it's your judgment call as to whether it's a compelling interest or not. That's the other part about it is the government has a thumb on the scale. If the government comes to the court and says we have a compelling interest, the court usually defers. The government says, yeah, we kind of agree with you and we kind of have to defer to you. Don't have to, but they oftentimes do. As applied, the act is sufficiently tailored to address the government's interest in preventing a foreign adversary from collecting vast swaths of data. To survive immediate scrutiny, all it needs is it need not be the least restrictive means of advancing the government's interest, which is where the TikTok lawyer failed emphatically in his oral argument. Remember when he was going down that chain of discussion for like 15 minutes of, but they didn't do anything else, but they didn't do anything else, but they didn't do anything else. Yes. As long as the regulation promotes a substantial government interest, it would be achieved less effectively absent the regulation and doesn't burden substantially more speech than necessary. It says that it satisfies those provisions. Oh, look at this. Roberts is giving homage to the Parade of Horribles. Petitioners parade a series of alternatives. These are things they could have done. They don't alter our tailoring.
But we don't care.
9-0. Yeah, that's what
because
it says.
the question is not what else could the government do, or even if you're a private party, what else could the private party do? It's was the option the private party took legal?
Yeah.
This is the question a lot of times. Sometimes I'll see this, for example, in a self-defense discussion. It's like, well, couldn't the person have run away?
Yes.
Couldn't the person have used pepper spray? Couldn't the person have called the police? I'm like, putting aside whether or not any of those things are possible, I'd rather just focus on what they did and to try to figure out whether or not that's lawful, not whether or not they had other options. So,
and I like that you use that context because how many times, and I like that you reframed it that way, because in self-defense cases, you see that issue raised and it always comes in late. And it's asking you to impose judgment, hindsight being 2020. What could you have done different? You didn't have to. That wasn't the question. The question was, did you have the lawful means of doing what you did?
Yeah. So this argument just kind of goes nowhere. Are there other things the government could have done? Yeah. The government chose to do this. Same thing with same thing also with the idea of, aren't there other entities that the U.S. government could regulate? Even other Chinese entities the government could regulate? Yeah, maybe. But they chose to regulate this one.
And honestly, this is where a lot of the Chevron cases, where I found myself in large part agreeing with a lot of the Chevron cases. And honestly, it was bad cases that got brought on this, where companies would challenge a law and say, this law is unfair. Look what the government could have done. And the government came back and a lot of times they said, yeah, they could have, but they chose this. They issued the rulemaking process. They went through and they told you why they chose this particular regulation and law. And that's what they did. They had the ability to do it.
I object on a visceral level.
Just because I said Chevron and
being
I said
mentioned positively in any sense.
Okay, maybe not Chevron. Maybe we didn't have to get the
Congress
Chevron for that
actually
analysis.
passed a law.
Yeah, in this case, Congress
They
was the
actually
one
passed a
speaking.
law. They should
True.
have just called it the anti-TikTok bill. It would have been easier.
No, they called
They
it
gave
what
the
did I-
protecting America from adversity. They just should have called it the TikTok sucks law.
No, they called it PFACA. No. Yeah, PFACA.
Yeah. Yeah, I should just call it the TikTok
I feel like
sucks law.
there's an opportunity lost there. They could have definitely chosen an acronym that would have been more slap in the face to, PFACA. And yes, it is still being said like Mufasa, because it just sounds good in my ear when I say PFACA. So in addition to the argument about the data collection, the government, they say they have an interest in preventing a foreign adversary.
I also liked on my channel where people were like raising some strange hypotheticals because like people's memories are just weird. Because every single time it's just like it was a weird one. I like the one today. Someone said, "Oh, we should regulate, for example, like speech coming out of the UK." And I'm like, well, it wouldn't be the first time the United States has declared the UK to be a foreign adversary.
And regulated things coming from the UK, including, tea, people, certain jackets of a certain color.
Yeah.
When it comes to foreign interactions, sovereigns get to do what they want to do in large part. It's like, imagine if a private citizen could sue and say, we didn't think that you needed to declare war. And Congress is like, it's kind of in our dominion to declare war. So, and the private person says, yeah, but there was an alternative to declaring war. And Congress is like, it's called diplomacy. We tried that too. We decided we didn't.
Or not. We just went straight to war because we can.
Went straight to war. It's one of those things where you might disagree with that decision emphatically. It's kind of the dominion of the sovereign to make that decision. So they say they don't want the foreign adversary having control over an algorithm that runs a widely used U.S. communications platform, and from being able to wield that control to alter the content on the platform in an undetectable manner. In a petitioner's view, that rationale is content-based justification that taints the government's data collection interest and triggers strict scrutiny. No, just because. Well, and I don't know that the courts can even concede that point. Yeah, here, there's no case where we're looking at both a content neutral and content based. Usually it basically says all you got to do is survive one of these.
Well, it depends if we're on stricter intermediate scrutiny. But if you're justified on content based, you're certainly justified on content neutral.
That's what I mean. Because if you're content based and you survive strict scrutiny on content based, the content neutral, you've already cleared that hurdle.
Yeah.
Oh, Roberts. Son of a bitch. Did it again. We need not determine the proper standard for misjustification cases. Then why did you mention it? How many times does he say we need not in this Control F? We need, if it's more than 4, we need not. Oh, son of a bitch. He says it 3. No. Said if it's more than 4, he says it 3 times. Fine. Even assuming that rationale turns on content, the argument fails under the counterfactual analysis they propose. The record before us adequately supports the conclusion that Congress would have passed the challenge provision based on the data collection justification alone. I don't think the court really needed to go through this. They don't have to go through and make analysis as to why Congress passed the law when you have one justification that suffices. That's just. I also don't like when the court goes into the legislative record, because we've seen how legislative records are made, and it's a whole lot of stupid. A lot.
It's Congress.
It's Congress. It's like, unanimous consent to introduce the 5 following articles that were written by completely biased individuals into the record. So ordered. So it all becomes part of the record. Petitioners assert, and that cuts both ways, guys. The stupidity that Congress does is not isolated to one particular party. It's just a whole lot of stupid. Text of the act itself undermines its conclusion, particularly argue that government's data collection rationale cannot justify the requirement that qualified divestiture preclude any operational relationship that allows for cooperation. What are you saying here? So they're arguing that the government rationale for the data collection restriction can't justify the qualified divestiture that requires any operational relationship be severed. No. The government's established that record. Under these circumstances, we find the government's data collection efforts just sufficient to sustain the challenge provisions. Oh, this is now the court saying sorry. This is now Justice Roberts saying sorry. There's no doubt that more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. So this is Justice Roberts saying, don't be mad at me. Your legislators have said this. Legit. He ends the opinion. He ends the opinion and says, sorry, folks, don't blame the court. Congress decided this.
Yeah. Legislature's going to legislate, baby.
Okay. Confirmed. Let's see. I think very limited. You had Sotomayor wrote a concurrence. All except Part 2A of the per curiam opinion.
She wants to actually conclude the First Amendment applies rather than assuming it, which incidentally the Court of Appeals also did. They also just assumed it. But she wants to say it. Whatever.
Okay. It's not the most bothersome thing. I mean, I don't mind that analysis. I think, am I going to agree with it? Hang on. Expressive activity by compiling. This logic could come back and bite Sotomayor in the ass. Let's say, for example, that we're talking about X's algorithm, the algorithm of Twitter. Sotomayor has just reached the conclusion that the algorithm itself is expressive content.
Yeah.
Okay. I'm fine with this. I don't mind that. I actually agree with that. Okay. I actually think I don't know if it's better or not than Roberts just saying, I don't need to decide that. Gorsuch.
I only think it's wrong in so much as the algorithm itself is not TikTok's. It's ByteDance's. So I think the error is attributing the speech to TikTok.
Yeah, that's fair. That's fair. That's quite an assumption to say that it's TikTok.
Yeah, I don't think it is.
Hey, Ian.
Hello.
So Gorsuch is complaining they only have a short time, short briefing. one man's covert content manipulation is another's editorial discretion. I agree with this, but I don't agree because this is also
it's
looking
foreign,
at a
though.
foreign company.
It's foreign.
That's where I don't agree with this. Is you're
Yeah.
talking about foreign entity.
Bunch of Canadians. I mean, Chinese.
Yeah.
What's the difference? They both start with C.
I have more guns. I'm
You.
looking into
Canadian have more guns. Many Canadians do not.
that is fair.
Well, then-
I am I'm gonna have some fun shopping at just at SHOT Show and just being like, all right, which of these things could I possibly get imported? Because that's gonna be an adventure. So
Gorsuch is Gorsuch is bringing in Whitney. You see this?
Yeah, I did see it. I saw it.
Gorsuch
makes
is
no
angry. I was
difference
like, okay, what's
that Americans like TikTok and corporate institutions may wish to make decisions about what they say in concert with a foreign adversary. Here's the distinction. People acting in concert is not a foreign government having the hand up the other one's ass and making the other one talk. Those who want our independence knew the vital importance of this freedom to think as you will and to speak as you think, as well as the dangers that come with representation. I'm with you, Gorsuch, and I get the Whitney reference, but not in this case. And I go back to that freaking. What was the question? Where's the lawyer? How do you start? I'm going to play this back. Ian, you didn't hear the beginning of the oral argument in this case, did you?
I did not.
You did not.
Otherwise, I
And
would
I
have
think
been
it's-
here to make a snarky comment about oral argument.
That's fair. I'll give you that. But in this particular argument, the lawyer just did something that I did not comprehend.
Are we going back to Bezos's children?
Yes, I'm going to Bezos' kids. You know I'm doing this. I'm not letting this go because I've
Wait, what?
never. Hang on. Where is it?
Yeah, it didn't really work.
Yeah, let's see. Let's just do a search for Bezos. Here we go. Okay. So right off the bat, Clarence Thomas's question.
You're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok. And I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights because they are ultimately the one that's suffering the burden under that law because they have to go dark and close up their books.
Counsel, you began by saying this is U.S. company.
It gets better.
You did have to.
Here's how it gets better.
And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose.
No. Your hypothetical literally just said that it's not Bezos' speech anymore.
Yeah. That's stupid.
I mean, what if they
I-
just said that Bezos can't say anything critical of China, but he still wanted to say things like, you know, about other people?
You mean we're demarcating whether it's what in this article is Bezos' speech? Here the question is, does the government need to do that level of articulation? Do they need to go in there at that point in time and parse the words and say, is this Bezos talking or is this China talking? No, I think once they have that factual premise,
when
they
the,
can
when the
regulate.
hypothetical is trying to force Bezos, because that was the hypothetical.
I mean, it was not a good hypothetical.
No, Bezos doesn't have a First Amendment anymore because he's being forced. So he's not making.
Yeah,
he's not
it's
making
like,
a choice.
what is your First Amendment interest in your compelled speech? Like, do you have a First Amendment claim to if some guy puts a gun to your head and makes you sit, like, you know, sing a stupid song? Do you have a First Amendment interest in that stupid song?
No.
I'm just like, I think this is kind of dumb.
And that, by the way, that hypothetical, he went with that 6 minutes in to his opening, to his argument. 6 minutes in.
See, I am a big fan of the hypothetical, but you got to be careful on your hypothetical. It's got to be a good one. And if you float a bad hypothetical, you've got to know how to cut that and run. Like, you cut the rope, you let it drop into the pit, and you're just like, okay, that's gone, never to be seen again.
At minute 4, the lawyer goes, so Jeff Bezos is leveraged. By minute 6, he's now, Jeff Bezos' kids are kidnapped. And you're like, whoa, what are you doing? Where are you going? Why are we here? It was horrifying. It was terrible.
Oh, this is the thing that really drives me nuts when you're sitting there watching like a Supreme Court appearance on fundamental freedoms and fundamental rights. And you're watching this and you're like, but this lawyer is a total numpty, and like the side defending free speech is okay, because I mean there is a free speech argument to be made here in terms of, you know, there are, you know, literally millions of Americans on TikTok, you know, communicating in a lot of cases stupid things, like some stupid dance that, you know, watch me do the Fortnite dance or whatever else. And sure, the like social interest in protecting somebody doing the Fortnite dance might not be super high, but I mean, there is good political commentary on there. There's all sorts of things. So, and the Fortnite dance, like you doing that stupid dance, is still protected speech, even if it's dumb. So
I streamed my coverage of the oral arguments to TikTok.
See,
that's
there's
true.
legitimate
that was protected
coverage.
Speech. That's protected.
But at the end of the day, you end up with some guy who's like, what if I kidnap Jeff Bezos's kids? And it's like, oh, this is the quality of argument we're getting. Great.
Yeah, and as I pointed out before, he was Solicitor General for 3 years. So he's not a numpty.
That doesn't mean he's not a numpty. Those two premises, like, one does not lead to the other.
Yeah.
Because, like, you know, Justin Trudeau was prime minister for however many years, and
this is a fair point. I stand correct. corrected.
Yeah, you just went to that part, so not going to fight you there. All right, let's see if there's any questions on it. Go ahead.
Our prime minister is still a person who can't be trusted around, like, you know, Halloween makeup. So,
you mean of the darker variety of Halloween makeup?
Yes.
I still can't believe that was real, but it was real. What was I going to do? Okay. So let's do this and see if there's any questions on the topic. Just because who wants to bet ByteDance, Courts Truth Social? I think ByteDance, it's why they have their algorithm. They want their algorithm. They have their platform. They have their algorithm.
They're not going to sell that algorithm to any U.S. company. They might sell the platform, but they're not selling the algorithm.
Yeah.
Algorithms,
and let's face it, that if you they don't want to, because that it's free data mining.
Well, I mean, the algorithm's what's worth money, and they're not going to give that away. It's like, oh yeah, give your the prime of your technology. No. So
Yep.
yeah.
AG seems like it's ceding a lot of power to the executive where weren't most of these positions appointed. I don't know. It's playing skip rope with the line for me. I don't really care for that part, but you have to give the power to some. Congress
I mean, it's giving a
regulates
lot
directly.
of power to the executive, but Congress chose to do that.
Yeah, Congress has the ability to do that if they want to, and they chose to in that instance. And you know what? You had two different executives exercising the power given to them under that authority. So you had the Biden administration, the Trump administration, you got any number of them. And you kind of have a consensus by both administrations. The Biden administration is outbound and they're saying they're not going to enforce this. The Trump administration inbound is saying they're not going to enforce this. So I don't know. I think it was pretty discretionary, but at that point in time, Congress did what they wanted to do. Canonical Heat, liking, subscribing, hitting the bell means your team will win the Super Bowl. No guarantees, express or implied. Thank you for putting that disclosure in there, Canonical Heat. I very much appreciate that, just so I don't get in trouble. Karen Ellis is the ban because the government can't regulate the content. I am so confused. Kurt, do you want to explain why they put the ban in place? And
Well,
maybe, you can describe it as a ban or not a ban.
The regulation ban is in place because the United States is concerned that China is using the TikTok algorithm to obtain user data from each individual user, including location, biometric, social data, contact data, user Wi-Fi data, what they're connected to, basically all the data. They're concerned that China is using the algorithm to feed the United States content it wants China wants the US to see, or not to see, as the case may be. So it's basically a massive intelligence gathering and information warfare tool by the Chinese government. That basically summarizes it.
Yep. Thank you. Very accurate. Torin 3, shop safety reminder, routers equal dangerous. Yeah, it's the most dangerous, one of the most dangerous tools in your shop. I accidentally fed my fingertip into a flush trim router bit. Oh,
you're lucky it's just a fingertip.
Word. Partly ripped off nail. Yeah. Torin, that must have given you quite a heart attack. I mean, that's... Whew. Yeah. Where? Sorry, I just got lost doing something real quick. Why?
There were some other Supreme Court cases that I've covered as well. We could talk about those if you want, while you're trying to find whatever it is you're looking for.
Yeah, let's get to these two questions first. This one I wanted to point out. This is starred. Thank you, Sandy, for starting this. Hello, I made it. This week I finally became a lawyer after 14 years since I started law school. 14 years is quite the route. Congratulations. I hope you are very much celebrating. Like, celebrate good times. Come on. That's awesome.
Did you learn the secret handshake?
Yeah, there's a secret handshake. If you need help learning it, we can teach you. I'm making that up. Only a little bit. Congratulations, Francisca. That is awesome. Runkle is the only beardless man in this triad. Yes, that is true.
I look awful with a beard. So, and Mrs. Runkle will veto a beard.
I still like mine because I don't have to shave for court. I like that. Just because, to clarify, my idea is that they'll invest in Truth Social to get the next president to throw his influence around to let TikTok back in the U.S.
Oh, they don't have to. I mean, Donald Trump has already invited the CEO of TikTok to the inauguration. And when it was still outside, he had a pretty prominent place on the dais. So yeah. I think that things are going to be fine.
I mean, both politicians are politicians. They are motivated by politics. And when something becomes politically unpalatable, for example, you have a bunch of people screaming about a platform going away, you lose the desire to push as hard as you want for an outcome. So, yeah. So, yes, Kurt, Supreme Court cases. What else was decided?
Not much decided. That's interesting. There was 2 kind of esoteric cases that were decided recently. In oral arguments, I was doing one that was pretty interesting on whether or not a misrepresentation can be considered false under some statute. Which I thought was
this the disclosures? This wasn't the SEC argument, was it?
No, this was a guy who had took out a loan and then misrepresented how much money he owed. And
interesting.
So there was an issue about whether or not a misrepresentation is the same thing as false. And then also today I did oral arguments concerning whether or not Texas can require ID in order to visit certain more adult websites.
Was that argued this week?
Yeah, it was argued 2 days ago.
Interesting.
Yeah.
What's your read on the argument?
I think the justices are kind of skeptical of Texas's thing. I don't know. I think it's going to be close. I think they're concerned about Texas's, and they're also concerned about the.
Is it the preemption argument?
No, they don't seem really interested in 230. That didn't seem that there was no discussion of 230. They seem to be completely focused on whether or not it's what the right level of review is on a First Amendment analysis.
And that seems interesting to me because I think the preemption argument would have been the strong, because you to say that this entire field's been regulated. No, because the 230 doesn't really touch the specific issue. This is kind of a nuanced issue.
Yeah.
Okay. I can see that. I get it. That makes sense. So oral arguments. I love that's I've told people in the past.
Hot oral arguments.
Oh my God. Yeah. I tell people in the past, the Oyas, just when they publish it, or you can now watch them on YouTube. Oye. I know I say Oya so people can look it up via the right phraseology. Otherwise people are going to look up
well, that's because they can't spell, because they don't know it's French. Lol.
Yeah. Lol. Let's see. Okay. I was going to do this. There's that. Okay. Now slice that. All right. Here's a copyright one. Ready? You'll like this. How much do you know about 3D printing, Kurt?
I know it exists, and it uses additive technology to do creation as opposed to subtractive, as opposed to old manufacturing.
Yes. Cool. Let's swoop to this. This is fun. All right. So 3D printing. I got a new 3D printer, by the way. And this is a great sidetrack where I can show you the thingy that, like, I am a complete immature non-adult. I printed a samurai sword. Ready?
Is that what that is?
Oh, hold on.
Okay. Neat. That is very cool.
Isn't it fun?
That is very cool.
It glows in the dark. I did this before I realized that there's a 6-year-old boy in this house that's probably going to hurt somebody with it. So now I have to find a place to either destroy this or hide this.
You don't want to destroy that, man. It's a work of art.
I don't want to destroy it. Maybe I'll bring it to my office, and for like misbehaving clients, I'll just whack them with it.
You can use it to solve divorce cases.
Wrong or right time. I don't know.
You can be Solomon and solve child custody cases.
Oh, literally divide the baby with a samurai sword that's 3D printed?
Yeah.
I feel like people would object to that. Well, anyways, I got a new 3D printer. It's awesome. It actually it came this week, and I've been tinkering with it nonstop because it prints like 6 times faster than my other one, and it has remarkable capabilities, including the ability to change out materials automatically and monitoring. And oddly enough, the week that I get this, there was some legal rumblings about an issue or a certain object that is a 3D printed issue. Oh yeah, I can keep the sword on hand for the Diddy discussions. Yeah, I can do that. It will be in near proximity to me.
Are we doing swords for that?
It might be.
I can get other swords, but this one is the one I've got handy right now.
we might be able to do that. So there's an object that's very well-known object within the 3D printing community. It's called a Benchy. And it is a little 3D printed boat. And if I pull this up, if you have been around someone with a 3D printer, you will have undoubtedly seen one of these because it is used to help benchmark people's 3D printer. 3D Benchy. It's an icon. So these little boats, this little guy here, actually what I was going to do, let's see if we can put this on quiet mode, and I can probably print one while we're talking about it.
I'm surprised they don't use the teacup for the for benchmarking.
The teacup?
There's various stress tests that you can do for your 3D printer. So right now my 3D printer is going to load it. And it's going to print a Benchy while we're talking about the Benchy.
Okay. Yeah, one of the first, I think it was the first scanned 3D object ever was a teacup. So it's his historical.
So the 3D Benchy. Love it or hate it, 3D Benchy is an icon of 3D printing world. Devised in 2015 as a free printer calibration tool, the little boat has seen millions of downloads across several 3D printing file share sites. It is literally everywhere. If I go to a website that has 3D printed materials or 3D printed models that I can search for, and if I search for the term Benchy, what you will see is you will see something like this, where there's all these different derivatives, and you see that people are using the original model and creating their own models. They're doing the Benchy in various forms, revisions. There's a looks like a, what is that? Blastoise Battleship Benchy. So everyone's remixing this. They're using the original file and they're remodeling the file to create different derivatives. The file is often included as a test print with new 3D printers. It is. And the speed with which the printer can spit one out is touted as a major accomplishment. In fact, we started tracking our own hardware speedboat test, blah, blah, blah. January 8th, a Reddit user voiced concerns that the owners of the little boat were lawyering up and coming after Benchy variants. So it's not really that they were lawyering up. This is kind of a misconstrued interpretation of what actually transpired. So Prusa's research platform, Printables. So if I go on Printables, because we just saw the platform called Things. Yes, it's called Things, and you can search for things that are 3D printed. But this is Printables. This is what they're talking about. Where if you typed in Benchy just a couple of 2 weeks ago, you would have seen tons of these different derivatives. But they've actually been starting to strike some of these models out. Creative Tools, which was a Swedish company that originally owned the 3D Benchy, they actually sold. And what people hadn't noticed was that the original licensing or the original creative works or the copyright on this was that where is it? Here we go. Commons attribution, no derivatives. That was the international licensor that this received, which prohibits the distribution of derivative works. You can print it. You can sell it. You can do anything you want with it. You just can't make the derivatives and market with the file. So you can do all these different things. It's fine, as long as you don't post the altered files. What ends up happening is that when Creative Tools was originally owned and created this file, they didn't care. They created a file that ended up being used to benchmark. They didn't care. It was 2015. 3D printers were a brand new thing. So they thought this isn't going to have any value to it. What are we going to do to defend this? So they didn't defend it. So they just let it go. Problem is, Creative Tools then sold their company to somebody else. And in selling their company to somebody else, what happened?
Did they extend a license out to before they sold?
The purchase of the company purchased all the IP. So
No,
when
but was there a
Creative-
license issued to the public, like a Creative Commons license or the like before that?
This was the licensing that was there. Creative Commons, attribution, no derivatives, international license, that was the licensing of the Benchy.
Then tough shit. That license is out there.
Yeah, but it's a no derivatives license.
It's a no
Yeah,
derivatives license, so people can't make derivatives, but they can make the original.
Exactly. Well, and that's the problem. No one's pissed off about making the original. It's the derivatives. So everyone who has these derivative models that are out there and the files that are out there and have the files available for download, all these individuals are now seeing that their models are being taken down or their files are being taken down off the different platforms. Well, where did this come from? Who initiated the strike? Who was the one that basically said, I'm enforcing this licensing restriction? People started blaming Creative Tools and they went back to the founders because the founders are very well known and they started yelling at them. Turns out they weren't the ones doing it because they had sold the damn company. Then they went to the new company.
If they wanted to prevent this problem, they should have, prior to sale, issued a better license.
Yeah. So they went to the new company. And the new company, oddly enough, the new company said, we're not doing it either.
Wait, what?
So what you're actually seeing is a lot of these platforms, a lot of these model sharing sites that allow you to post your different files, they're taking proactive steps. And what's interesting is I don't know that a lot of their own internal policies were ever being monitored on this. So all these platforms have policies on there that you can't put you can't put STL files or 3MF files. You can't put files up there that would violate someone's copyright. So they have that policy in there. But I don't know that they ever enforced it unless the individual whose copyright was being violated or whose license was being violated actually sought the takedown. So here you have a file, this 3D Benchy that's existed since 2015 that everyone has basically been using and making derivatives of and posting the files of for the past 20 or 10 years. And now everyone's like, oh, wait, we weren't allowed to do that. And the platforms, not the company that owns it, the platforms are the ones taking down the models. Arguably, because the individual who does the derivative, you're going to sue them. How are you going to prove that they economically harmed you? And how are you going to find them? Because most of these people are just usernames. But if you sue the platform, not to say the lawsuit would go anywhere, but it's basically a proactive step by the platforms themselves.
Oh, this is giving me a headache.
I know. But it's fantastic because it came up the very week that I got my new 3D printer and printed a Benchy.
How are they determining whether or not it's a derivative? I mean,
and this is the thing is they're closely this part. Joseph Prusa, or the person who's the chief marketing officer for Printables, said that they are. I mean, imagine this nightmare. They would be closely examining all Benchy remixes to see if any could be allowed to stand as quote unquote transformative works. So let's just go back and try to do the analysis or any analysis, just looking at a few of these different models. And there, if we're looking here, so how would you say that any of these are derivatives? So that's clearly not transformational. Neither is that. It's pretty much the same exact model. This guy, is that transformational? Sufficiently transformational.
no.
Right? Because it still uses that image, which is pretty easily identifiable and distinct.
And they specifically noted as an epic story of Benchy, which is not a
Exactly.
great strategy if you're trying to be avoiding litigation.
Here's an even worse one. It is literally just a Benchy just with lattice.
So it's basically hard mode.
Yeah. No, I want Benchy. So now you have these platforms that are going out there with all these printable files. Now, mind you, some of these printable files, some of these artists monetize their files. So in order to download the file, you have to pay a contribution. You have to be a member to the artist or something like that. Now, in the Benchy circumstance, I haven't seen any Benchies that have been monetized. This one, you know, I might give a derivative work. They put the Rock's head. It's the Rock. It's Dwayne Johnson. It's the Benchy, but it's the Rock.
Well, then you're also running into problems of what do you call of
Appropriation
using
of
the Rock's
likeness.
image. Yep.
So that's the Rock. Where's the other one? There. That looks surprisingly like Jeff.
Well, let's have a look at
But
that
it's
little
Stalin, so we're
trireme.
not going to say that.
The trireme there
Where?
at the bottom, bottom middle. Yeah.
This guy?
No, one to the right. There we go. That one. I mean, that seems
That's
to
not a
be
Benchy.
a new work, but it's noted
Yeah.
as Benchy torture test. So I think they might have a hard time getting the Benchy trademark, given that there's a ton of.
Yeah, that's clearly not the Benchy. So catamaran. Now all these things are cool and you can print them, but this is the sad part about it is a lot of these things are very cool techniques that they did with the original file, and they're now being stripped out of the marketplace. That's cool. The ghost Benchy, spooky.
I mean, that one does seem to be transformative.
That's tough though. This is fun. That's a fun little thought experiment here. Can you? That's pretty good. You have cloaked it, but in doing so, you've taken away a lot of the features, leaving only subtle hints of the features that would allow you to identify it as the original object.
Well, you want to even make an argument it's not derivative, it's just a completely original work. Idea expression dichotomy. You want to go one step more?
The thing is I suspect it is derivative because I suspect that they needed to use the original Benchy file to create this. In that I suspect they took the original file and then put something over it and then deleted the Benchy out of it.
This is a cool file though, because it looks like they took the Benchy, rotated the axis, and tilted the axis,
and then put something over it and then removed the
it.
original Benchy out of it.
That's pretty cool.
That's my suspicion
clever.
as to how it probably would have been created. Which, yeah.
Does that mean it's derivative within the meaning of copyright law? There might be an argument in there somewhere.
I think that you could argue that, because there are Benchy elements that are still visible in it. But,
yeah,
but still very transformative, right? So,
I don't know. Give me $100,000 and I'll figure it out.
Give me $90,000 and I'll figure it out badly.
Well, I just think that it's interesting that you have this massive takedown effort by these different platforms, and the person who owns the license is basically saying, hey, we didn't tell you guys to take this down. Now, they're obviously not objecting to you taking it down because they own the license. Why would they object and stop you from taking it down? But why? Oh, that's got the birds on it. Haunted Benchy. That's cool. Duck Benchy keychain. That's fun. There's another spooky Benchy. Airplane Benchy. It's a Millennium Falcon Benchy. Hang on. The turret. That's great.
Some of these things seem to be a lot more creative than the original Benchy was.
So here's an additional article that was on Hackaday. So again, this is the question from that original Reddit user. Or no, this was one of the takedown questions. And this was the editor's note that came in after the original article was made. A few days later, it now looks like Prusa pulled the models of their own accord because of their interpretation of the copyright law. Creative Tools and NTI claim that they were not involved.
Well, I don't know if it has any value to the IP owner, but the IP owner could obviously solve this by releasing it under a more permissive license. That would solve the problem.
Just public domain it, guys.
I'll do it.
I mean, they could very easily.
Yep, just public domain the thing. And then everybody's happy. Except your lawyers, but they'll get over it.
Yeah. Let's see if there are any questions. I told you it was a really short topic. Cross-stitch 626 CNN headline says TikTok will go dark on Sunday unless Biden intervenes immediately. CNN just lost.
Biden is not going to intervene.
I don't think there's no one's going to come and what's Biden going to do?
I don't know. So it goes dark for a day. We'll all live, I assure you.
Yeah. I don't like this brinkmanship argument on this stupid thing. And it's been this way from the very beginning. If they wanted to divest, they'd divest. If they wanted the platform to continue, they would continue the platform. Now, the other thing that I've seen is that a lot of these creators are now flocking to these other platforms that are also Chinese company owned.
Yeah, I don't get it.
Oh, you mean Redbook?
Yeah.
Yeah, I feel like there's a little bit of own goal on this one, where it's like, oh, we've gotten everyone off of TikTok, and oh, they're going to something much worse.
Like overtly stealing your data, like created for the purpose of stealing your data and intentionally delivering it.
And it's specifically, I mean, somebody posted up the terms of service for it. And the terms of service are basically like, if you post here, we own your likeness forever and can use it in any way, including in like hardcore deepfake porn. And it's like, okay, those are some license terms. That's exciting. It's like, we own the copyrights, not just to what you post, but to every other idea you've ever had or like encountered. And it's like so sweeping. I'm kind of surprised that it's not like, we also own your colonoscopy results. And so, yeah, I guess the government's going to have to get on banning Redbook next. But
well, I mean, ostensibly under this existing legislation, they could immediately come in and begin the review process to determine that this is
But the really hilarious thing is the cultural interchange happening right now on Redbook.
That's my personal favorite part. It's like, if it winds up red pilling Americans, I'm all down for it.
Well, especially with the 3D gun printing community is going on to Redbook and is like, here's how you print a gun, Chinese nationals. Which could be exciting.
Why the Chinese government has now introduced a term that says if you're a U.S. citizen, like they've started banning U.S. citizens from adding this app.
Yeah, it's there are people posting. There was one guy who posted like, somewhat political content. They removed a couple of his videos because they were political content, and then for like a couple of hours, he was like a Tiananmen Square theme account because he was pissed off about having a couple of videos removed. So it was like, all right, it's all Tiananmen Square all the time. And yeah, he lasted about 2 hours before they banned him permanently. But yeah, there's a lot of fun there. It's interesting.
How do you even pronounce this? Xiao Hong Su? Is that how you pronounce the RedNote, that app?
I don't know.
I assume it's not really going to go anywhere. I assume it's just, some people trying to be rebellious, but it's not really going to go anywhere.
Yeah, it's a whole bunch of people who are pissed off that their, million user TikTok account is going away. Lauren the Mortician. Eat that entire plate of crap. I wonder
Just
how
looking at
she's
these-
doing right now. Also,
looking at
random side tangent. Me and Mrs. Runkle were dropping the dogs off at dog prison because the dogs have a terrible lawyer.
What? You wrongfully incarcerated the dogs?
They're at the dog dog daycare there. They're going to be having a wonderful time while I'm in Vegas. So,
hey Rob, do you want me to bounce?
It's up to you. I'm almost done with this one. I actually had the RedNote here. You can stick around for the RedNote because I actually have the terms of service pulled up.
Oh, this will be good.
This might be interesting.
But we stopped on the way back at a little pho place, and she ordered something she thought was like the peanut satay, but it was actually the spicy soup. And so they delivered it, and they put my order in front of her and her order in front of me. And I was like, well, I'm still going to try it. And I tried it, and I'm like, you want to switch? And she's like, no, I want what I ordered. And I'm like, you want to switch? So I give her, her bowl, and she tries it. And she's like, can I have yours? And I was like, yes, you can. Because this spicy soup is lethal. And like 5 minutes later, she's like, I can still feel it. And I'm like, mm-hmm. I'm going back there. The spicy soup is spicy. I'm a fan.
Well, if it's spicy for you, then it's spicy. So let's see here. So this is being personal information in accordance with the cybersecurity law of the People's Republic of China, the personal information protection law of the People's Republic of China, civil code. Policies closely related to our products and services. We will process and protect your personal information in accordance with this policy. By the way, this is translated via Google Translate. So if it's inaccurate, it's just Google Translate. We're going to explain them concisely. The clauses in this policy that are/may materially related to your rights and interests have been distinguished by the use of bold fonts. So please pay attention to them. How many do you think are not bolded? Serious?
I might be surprised if there was no like super tiny font in this anywhere.
It's a lifestyle platform for young people with a mission to inspire lives to share and discover the wonders of the world. Record their lives through short videos, lifestyles, blah, blah, blah. Explain to you the scope of the personal information that we may collect by each function. Purpose of collection, the method of collection, and the possible consequences of refusing to provide personal information. Please be aware that if you refuse to provide the corresponding information necessary for the implementation of various functions, you can still use other functions of the app. Yeah, like brick. App becomes brick when you don't give me information. We will follow the principles of legitimacy, legality, and necessity to collect and use personal information you voluntarily provide or generate as a result of using our products. If we want to use your personal information for other purposes not specified in this policy, or use the information we have collected for other purposes for specific purposes, we will inform you in a reasonable manner and obtain your consent again before using it. Okay. When you register, you create this mobile phone number and network operation information. Also collect gender, interest, and age. If you don't wish to provide, you can say skip. Third-party account to log in. We will collect your mobile phone number to complete the real name authentication. Choose to fill in to provide products and service to you. So let's say these are the purposes. So information, browsing, publishing, liking, favoriting, and sharing functions. In order to provide you with our core information display services and recommend notes and related information that may be of interest to you, we will collect. Here's what they collect: your personal information, gender, birthday, browsing history, your follow, browsing, click operation records, interest, clicks, searches, likes, favorites, shares, comments, posting records, and related behaviors. What are related behaviors? That's not very well defined.
That's everything. It's basically they collect every time you touch the app.
If
Or
you
think
turn
about
off,
it too hard.
If you turn off our recommendations, you can refer to Article 2.14.
Which just says, up yours.
You authorize the storage on our servers. Publish notes. Geolocation stickers. We will use your geolocation information to generate stickers with your authorization. Displayed publicly in the content. Location information and media information. When you enable and use the limited memories function, we will automatically analyze and filter the pictures and videos in your device's album based on the shooting information, time, scene, location, generate videos for you. For the best editing results, we need to collect shooting information for analysis before each video is generated. So the macro data on each of your images. Recommend or discover friends. We will encrypt and upload and save your contact information to our server for recommending your friends and people that you may know. In order to ensure the safe operation, unique device identifiers. Yeah, but their unique device identifiers are basically anything. We will analyze and collect your search instructions, reading records and access times, comments and interaction records. So all the data TikTok collected. When you follow an account, browse, comment, like, favorite, and share content. Collect the account you follow and the aforementioned information. Show you the content posted by the account. Functional services based on geography. Live room interaction. If you're a live streamer, your nickname, profile picture displayed. All this stuff is shown and kept. Purchase inquiry and virtual property. In order to facilitate your search for virtual assets and minimize possible risks, Wallet will record your deposit balance and usage. I don't like that. Real name, ID, number, and photo and facial recognition information to verify personal identity. ID number or photo. I guess that's, I don't know how, that's authentication records. Cooperation, customer service, call recordings, that's fair, blah, 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 communication. Wait, what? Product purchase function. Oh, you got to provide pictures of your license.
So far, this is all just what every company will try to
every license thing is probably language to deal with countries that require customs. That, like Korea.
Yeah.
So that's probably why that language is in
payment
there.
accounts. Skin analysis and makeup try-on features. When you use the skin analysis or makeup try-on feature provided by this, we may need to collect your storage, photo albums, media, and other files. Whoop. Camera permission, facial information after obtaining your separate consent through a pop-up windows. We do not store that information. If you refuse to provide the affirmation features, you'll not be able to experience our skin analysis. Okay. Ensure containment of communication. Search and display. Browsing usage. If we combine it, then we consider it personal information and we anonymize it. Okay. Ooh, let's see. Are there any that cannot be turned off? All of these, they say they can be turned off. I don't know if that's interesting. Exceptions to obtaining authorization and consent. In accordance with the provisions of the relevant laws and regulations, we may collect and use some necessary personal information without your authorization and consent under the following circumstances. It is necessary for the conclusion and performance of a contract to which an individual is a party, the implementation of human resources management in accordance with the labor rules and regulations formulated in accordance with the law, and the collective contract signed in accordance with the law. What the hell does that mean? Oh, here you go. It is necessary for the performance of statutory duties and obligations, which we already know from the fact that this is incorporated in China. That includes cooperation with intelligence. Where it's necessary to respond to a public health emergency.
I wonder how many
protect life,
people are in the
health, and
future are
property.
going to apply to become like spies. And one of the questions will be, have you ever posted your face to something like RedNote? Because can you imagine you go to the border and you like, you know, you're traveling under an assumed identity because you're a spy, and you get up there and you're like, I'm so-and-so, like carpet merchant or whatever. And they're like, yeah, that's not the name that comes up based on your past use of RedNote. So
look at the exceptions. Look at the exceptions to what you had. So they don't have to get your authorization to collect data if it is necessary for a public health emergency or to protect the life, health, and property safety of natural persons in an emergency. All right, maybe carrying out news reporting, public opinion supervision, and other acts for the public interest, and processing personal information within a reasonable scope. Well, there's your loophole. Other circumstances stipulated by laws and regulations.
I mean, let's face it, the loopholes on this are going to be broad enough. They're going to be wide enough that they are collecting high scores on OnlyFans.
Yes, probably.
Nice.
Public disclosure.
I like to keep it topical.
How we store it, how we protect it. It's a whole lot of data that you're signing up to.
I just don't get it. Like, I don't understand why people would sign up for this random app that no one's ever heard of before. It's strange. People have a very
I'm
strange
pretty
sense
sure
of
it
spite.
was. I suspect it was RedNote doing some heavy paying people to advertise RedNote.
Oh yeah, it's showing up in all these massive content creators. Like they're like, "Here's my RedNote page." Blah blah blah. I'm like,
no one's
thanks.
offered me a deal yet. If there's people out there looking for creators to show RedNote, I have very affordable rates. Contact me.
Oh my god, I cannot.
I'll even try to
imagine.
learn some phrases in Chinese.
He'll do it for $12, folks. Okay, maybe not. $1,200 though. See, we got the eyebrows. The eyebrows say 1,200.
See, and we have a Benchy.
It's very blurry. You need to recalibrate your. You need to recalibrate it. It's very blurry.
No, it's not. It's good.
It's a beautiful boat.
It is a beautiful boat. Lovely. Okay. All right. So we've talked about TikTok. We talked about the Benchy. Baldoni or Diddy? I can tell you the one I'm more prepared for is Baldoni.
I just put out a a
Video on the
1-hour
Baldoni?
video on Baldoni, which was like, let me, it was kind of the, let me explain. No, there is too much. Let me sum up. And it was still an hour and 10 minutes because
it's 179 pages.
Yeah, if you're wondering, I was joking that if you're wondering why your movies are like, 3 hours long, it's because of that.
And it goes through in great detail. I mean, the lawsuit itself has screenshots of all these text messages. But maybe, you know what? Let's read the foreword to the lawsuit, because that's only 10 total pages.
That's a long forward,
dude.
I've read. I've read lawsuits shorter than that.
When I say it's 179 pages, I mean it is. I don't know that I've.
There should be a law against this.
There should be a law that if celebrities get into slap fights using the court system to, avoid defamation claims, that they have to pay every single dollar of the cost to the public.
We might get another Johnny Depp trial out of it, though, so that'd be exciting.
I don't think this is quite Johnny Depp, but it's got some similarities. But
I will tell you, if this gets to discovery, they have absolutely indicated in no uncertain terms that we are going to get depositions and deposition videos and all of the stuff.
Oh yeah,
I mean, that's why I want to read that foreword, because the foreword is probably one of the more scathing things I've seen. And I say the foreword, basically the lawsuit itself doesn't get into the causes of action until like page 158.
My favorite thing about this lawsuit, or about his filings, though, is that he gives you some real subtle hints that he's like, oh, this is not going to go how you planned. And assuming he can back up what he's claiming, I think this is going to get real interesting, because he says, like, there's several places where he's like, did you forget that this was a film set and that we record things here, and that as the guy behind the production company, we have the video, we have the audio. Did you forget that? Because there's a moment where she's like, she previously talked about this like dancing scene, and she's like, where no audio was recorded, and he's like, actually it was, I was mic'd up, and also the chat is saying Diddy, so we might be overruled on this one.
I've got this pulled up. It's not going to take me long. I know that Diddy is on everyone's palette to discuss. I'll discuss it. It's not going to be the longest discussion in the world. This one is I like reading scorched earth filings. This is a scorched earth filing. This is I am going to burn this motherfucker down. That's what this is. And you can see I've already highlighted different parts of it too. So the following is not a story plaintiffs ever wish to tell. Unfortunately, defendant Blake Lively has unequivocally left them with no choice, not only to set the record straight in response to Lively's accusation, but also to put the spotlight on the parts of Hollywood that they have dedicated their careers to being the antithesis of. Hang on, I got to swoop. It's my bad. Swoopy swoop. Swoopy swoop. This is great. Paragraph 2. Had Lively chosen to merely ride out the self-inflicted press catastrophe she faced in August of 2024, the public would likely have moved on and never known the truth about her. Just shots fired immediately. They would have never known that she deliberately and systematically robbed plaintiffs Baldoni and Wayfarer of their movie. No one except the parties involved would have known that she used threats and extortion to relegate the colleagues she once highly praised to a basement to sit out their own premiere, while she enjoyed the spotlight of a premiere and after party that was ultimately co-financed by both.
It's clear he's super salty about having to pay for the party he didn't get to go to.
Oh, pissed.
Like, that is the thing that has him. He's so salty about it, and It's kind of funny because he includes pictures of the party he ended up at.
Yeah, that's a quick skim. Like that we can get to towards the end of the complaint. We're probably
They're sad.
later 2/3.
Well, I think I'm going to go ahead and sign off while I can and let you guys get to it.
Okay, thanks for being here,
All
Kurt. Much appreciated, my friend.
All right, talk to
Good
you
night.
later. Bye-bye.
See you, buddy. She would have gotten away with these things and more because Baldoni focused entirely on seeing the film succeed. Would have held his tongue as he had through the year and a half that Lively tormented him, his family, and his partners. But Lively could not tolerate her publicly tainted image for even a moment. And further could
She
not
also
accept
like the and she would have gotten away with it too if not for those meddling kids
those meddling
moment.
kids. Yeah. It is rather, it's interesting, but it also does a really good job of the prior complaints, made allegations. This one comes in swinging at the person, not conduct, not a lot of their stuff. It takes direct swings at the character of Blake Lively and Ryan Reynolds. She couldn't accept that it was of her own making. She needed a scapegoat. And rather than admit and take accountability for her own mishap, she chose to blame plaintiffs in a malicious and unforgivably public manner. When she and Reynolds could not force Baldoni and Wayfair to read a statement she and her representatives prepared, exhorting them to take accountability in defense of Lively's actions, she lay in wait for months, preparing to publicly attack Baldoni by falsely claiming that he had sexually harassed her. These are a lot of very, very, very strong allegations.
Oh, he came to play.
The same falsified story she had calculatingly devised and used through the production of this film in order to take control were now being used publicly to destroy Baldonian plaintiffs. Lively stole Wayfair's movie, hijacked Wayfair's premiere, destroyed plaintiffs' personal and professional reputations and livelihood, and aimed to drive plaintiffs out of business entirely. Further appears that she worked equally with the powerful New York Times to prepare a false and damaging narrative to deploy against plaintiffs. Not surprisingly, she prepared an administrative complaint with the Civil Rights Department in California in an attempt to use the litigation privilege to shield her behind-the-scenes conspiracy with the New York Times. But on information and belief, this is the part where it's like, yeah, he does a lot of this a little bit. You're allowed to, but a little bit. But this is a pretty easy conclusion to reach given what we know. The CRD complaint was filed only after defendants spent months feeding falsehoods in the New York Times, intending that they be disseminated to damage plaintiffs. She delivered.
I don't think that they pushed it too far on the information and belief.
No, not they did it where you could logically make conclusions, and they also did it when they talked about Lively's motives, which I think again you can construe that.
Yeah, it's not like some lawsuits where they like information and belief, the entire factual framework.
Yeah.
So, yeah.
On information and belief, the other person did a bad. No. So, it was rife with lies. So she files the CRD complaint. CRD complaint picks up the basically the New York Times conduit. Then she waits 11 days to file suit against the plaintiffs in what seemed to be a desperate move after the public questioned why she had never filed a lawsuit. This was something that I was wondering, why would you do this? Why would you open the door to discovery by filing the lawsuit yourself? Why?
Well, because she pretty much had to, because, yeah.
On information and belief, Lively never intended to file a lawsuit, which would have triggered plaintiffs' right to discovery.
Yeah, that is a little too far on the information and belief, but it's like they're not going to get busted for it.
Nope. But it's very clear that he wants it, including obtaining evidence and deposing Lively under oath. They want depositions.
Oh, they're and the thing is if he's correct about having all of this information,
it is going to be annihilation. Yeah.
If he's truthful, if he's correct about what he has and so forth, then Lively has badly misplayed this.
And
Now, if
mind
he's
you,
not,
what he has placed in the lawsuit, what he's placed in the lawsuit, and it's also not just what he's placed in the lawsuit, but even in the very beginning of it, he says, we're not coming in with selectively edited parts of this. We are bringing you all of it, which suggests to me that he has the goods.
either he has the goods or he's about to get burned by the courts. Because
Yeah.
if he doesn't have the goods and he's saying he's got the goods in the way he has, then he's in trouble, right? Because you can't bullshit the court as thoroughly as that would be.
Oh, Elf Liggins, the allegation isn't that the lawsuit was filed in reaction to his. It's not. The allegation is that she filed the lawsuit because she felt that the complaint and the New York Times article weren't doing enough to change the narrative. It wasn't doing enough to put him in the ground. She needed him in the ground to the point where he was running away rather than fighting back. Plaintiffs now have no choice but to fight back, armed only with the truth and the mountain of concrete evidence disproving Lively's actions. Heartbreakingly, a film that Baldoni envisioned years ago would honor the survivors of domestic violence by telling their stories with a lofty goal of making a positive impact in the world has now been overshadowed beyond recognition solely as a result of Lively's actions and cruelty.
He does get a little overwrought at times.
A little bit. So he
But
talks
I mean,
here
fair
about
enough. He's allowed.
the use of power to seize control of the film. Now, this is something that's more personal, right? The use of power to seize control of the film. Now, then we go. Wayfarer was equally blindsided when Lively leveraged this document. So now we're talking about the protections to return to work. So that 17 bullet point argument document that they signed, which was annoying.
Because you're like, why would you ever sign this? Don't do that.
And Baldoni, it gets basically acknowledged by the lawyers in here. That's Moondragon. That's the other way around. You had to file the civil rights claim before you could file the personal civil suit.
Yeah.
But just because you file the civil rights claim does not mean that you have to file the civil lawsuit. So civil rights claim first, civil lawsuit second.
And you don't have to file it. You can
Correct.
just like let it go.
Yep. Wayfarer was equally blindsided when Lively leveraged this document, essentially signed under duress to seize control of the film, ultimately getting her own cut of the film at a coveted producer's mark, and at her command, ousting Baldoni from all marketing and promotional efforts with many of the cast members and the author, all of whom he until then had long-standing positive relations with. So this
Now, here's
actually,
the thing is,
go ahead.
like, he's like, I am the most innocent person ever. And it's like, okay, but if that's the case, why did the author dump you? Right? There's a bunch of questions I have on both sides. And
Now,
this whole
what he
case is super awkward.
suggests, but what he's suggesting is that by ousting him, by having this control and by restricting where he could be at certain times, it gave her basically exclusive access to start shifting the narrative.
Yeah,
That's the
but
suggestion.
still, it still is a little bit.
It's rewriting.
Yep,
Well,
and
it's glossing.
it
It's
just
glossing over stuff.
it leaves a question in my mind as to what was actually going down, and
Yes.
it's one of those things where it's like, I want to hear from the author. I want to hear that, right? So, you know, because as much as I read Baldoni's thing and I'm like, I mostly think that it's credible and whatever else, but there are some strings. And the same thing happens with Lively. Like Lively's complaint, I still have stuff that I'm like, I want to pick at this. This doesn't make sense to me. So all of it is kind of an issue.
One person seems a lot more confident in what the evidence is going to show than the other.
That is true.
Well, I mean, one person seems a lot more confident in full disclosure than the other person is. In the Lively's complaint reads like a very narrowly tailored argument based on best interpretation of evidence. Baldoni does best interpretation of evidence, but also is more focused on the whole picture. However, I don't know if that whole picture is going to save him the way that he thinks it does in every respect. Is that a fair kind of synopsis of what your thought process too?
Yeah, there's just a few places where I'm like, this might be a little awkward. I don't know. We'll have to see, right? But
so Lively's exclusion of Baldoni from the promotion of the film backfired as she chose to callously promote her hair care and alcoholic beverage products rather than bring attention to survivors of domestic violence. Baldoni, now prohibited from attending events or taking photos with Lively and the cast, promoted the film as he always had and had always intended ever since he first began the process of making the film years ago. Does he go more into the prohibition from him taking photos with Lively?
a little bit, yeah.
I thought that felt weird to read.
Yeah.
When Lively faced significant public backlash for what was often referred to as her, quote, tone deaf, end quote, and insensitive press tour for the film, she doubled down on her false and misleading accusations against Baldoni. She seemed determined to make Baldoni the real life villain in her story. Her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, I use this because it was first mentioned to him in the lawsuit, also used to describe Baldoni when he called Baldoni's own agent. Now he goes through this connection that, yes, once the accusation is made, your life is ripped to pieces, which is pretty amazing. Once that accusation gets floated out there, the amount of weight that accusation generally carries is pretty shocking, even without corroboration. She did not expect, however, that plaintiffs would be able to meet those allegations with concrete documentary evidence disproving her claims and demonstrating that they, not Lively, were the targets of calculated and vitriolic smear campaign. The film was hotly anticipated, worldwide best-selling book. I don't know who anticipated this film. I didn't hear about it, but
I am told it did really well.
Okay.
Apparently it made millions of dollars, like more money than I will ever see in my lifetime.
Yeah, how much would it have made if the fireworks hadn't been happening towards the end?
$12.
But she was not content to merely headline one of the year's biggest movies. Instead, apparently driven by overwhelming ambition and need for control. This part was interesting. In an early meeting with Baldoni, this footnote, Lively foreshadowed what was to come, stating, "I'm afraid you have too much power," referencing Baldoni's dual role as producer and director. The problem with that statement that I have here is there's no context for this. It just makes a simple one-off. I'm afraid you have too much power. Ian, I'm afraid you have too much power because you can make things happen on my channel. Like, it doesn't mean that I'm foreshadowing with something to come.
Rob, come on.
Bring this jury. We have questions.
Ian, continue.
Push buttons, wiggle joystick.
Okay, so says that she wants control. This part made me chuckle a little bit. Not only did Lively's power play cost numerous people their jobs, but at every turn, her wrongdoing, her wrong-headed creative decisions reflected her fundamental lack of understanding of the book the film was based on. This came as no surprise to her worried colleagues, given that even well into production, she had not read the book. This was interesting footnote too. She later claimed she read the book, but text evidence shows that well into production, she had not, and in fact expressed she had chosen not to read the book. She even tried to Google the color of the hair of her character's hair rather than pick up the book. I want to read that text exchange because that's...
The thing is they actually provide that text, and the problem is it's a September 14th text from Baldoni to Heath.
Yeah,
so it's like, we have proof
so
that she didn't read the book. It's a text from me. And I'm like,
at least
wait.
There it is. I don't know whether... Yeah, that's one of the things. You're going to promise a text message. You're going to give a self-fulfilling or self-assisting statement, bolstering.
I mean, the thing is if they get passed into discovery, and this is the other wonderful thing, is that if they get into discovery on either file, because let's say if they get into discovery on one file, they're immediately going to like refile a whole bunch of stuff and all of that. So it's yeah.
Also, Baldoni's lawsuit makes it expressly states that he has every intention of disseminating everything that is divulged in discovery publicly.
Oh, absolutely. And the thing is I suspect Lively has every intention of divulging the best bits, right?
Yeah. Slash, like, if Lively sits for a deposition, I cannot imagine that they're going to be happy if that deposition tape ends up on the internet. A la Amber Heard's depo.
They may actually have they may embargo it. And I mean, I'm aware of a case here where they basically said, okay, so here's the rules. If a deposition tape, we are watermarking every single copy of the depo tapes.
Mm-hmm.
And whoever leaks this is going to face sanctions greater than the value of the case. And yep, they nothing leaked because the judge was just like, yeah, every depo tape goes to me personally first, and I will send each lawyer a watermarked copy. And whoever leaks it, I am going to come after you, and I will hunt you in your dreams, was basically what the, was like, yeah, there will be sanctions. The sanctions will exceed the value of the case. And at that point, you could fight over the scraps. So, yeah.
We'll see. It's going to be interesting. So it talks about the past videos that came resurfacing that showed her as a mean girl, and then talks about the promotion of the alcohol, and then goes on to say that Lively made this harmful and irresponsible message regarding the alcohol and domestic violence, the fact that they usually coincide, or they coincide 55% of the time, by naming a drink at her premiere after party while you wait.
Oh, I love this
character.
part.
She committed who committed domestic violence in the film.
Isn't literally that like? But the thing is that is a brilliant thing to put in the filing. I was just like, Baldoni's lawyers are playing some chess here, because they're basically saying, listen, they're saying we did this. There is literally no way, we had no ability to put this crap into her. We couldn't name her drinks. We're not the people who did this. This was her choice. And
I will tell you, it is a choice.
I think I described it in my video as this is a whole entire choice that they made here.
Yeah. Like, one, promotion of alcohol when you have a video that's talking about domestic violence. Very stupid.
Yeah.
2, connecting alcohol and an alcoholic drink by name to the person in the movie who's the aggressor.
Naming the abuser, like naming the drink after the abuser, is a whole decision, right?
Yeah.
It's like, if I have a hot sauce, I'm not naming it after, like, I'm probably not naming it after a serial killer. Or maybe I will. I don't know. Maybe that.
I mean, the only thing dumber would have been if she owned like a athletic wear and she named a set of boxing gloves. Like, like, you know what I mean? Like, it's.
Ooh, Rob, that is darkly hilarious.
But it's that stupid. Or it's like Amber Heard with the makeup kit, the bruise kit.
Yeah.
Her going out there and saying, ladies, as a promotional thing that you're taking away from this video, here's a bruise kit. and it's called, in case he hits or something. I mean, there's just it's tone deaf. So sadly, the backlash could have been avoided had she not refused to meet with the film's domestic violence partner organization, nomore.org, as Baldoni had offered. Even a brief visit to their website or a simple online search would have readily uncovered this and other information on the topic of domestic violence. Meanwhile, Baldoni, whom Lively herself had ensured was excluded from the participating in her marketing efforts, was safeguarded from this backlash as he focused on amplifying the voices of those affected by domestic violence. So it basically says, I wasn't in the room. You made the decisions. You excluded me. You reap what you sow. Lively, enraged that her plans were foiled and armed with, quote, proof of alleged sexual harassment in the form of a 17-point list of demands she had required plaintiffs to sign just months earlier, focused her rage on Baldoni, blaming him for the consequence of her own missteps. This is why you don't sign the fucking 17-point demand. When they walked in, what did I say? When they walked in, you basically say, sorry, this movie's now burned to the ground.
Yeah.
So then they talk about Stephanie Jones, who's the publicist, who's been outwardly spoken against Wayfarers and sued the Wayfarer. But they depict her as just becoming more and more aggressive. I don't know. This is the other part that I had a question about. They really show her in a very, 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 very negative light and suggest instability. But I don't know that there was a whole lot of receipts here to back this up other than these two people they were at odds. Now, what was fascinating to me was that Abel, who had told that she was going to leave Jones Works to form her own company, when she left, apparently now we know where all the text messages came from.
Yep.
Because Jones seized Abel's phone upon her leaving. Which the part that I think is kind of corroborating what the allegation here is as to Jones is that if you are engaged in PR, if that's your job, you're PR, right? Your ability to maintain privacy of your clients and communication is pretty significant. It's a pretty significant trait that we look for, right? You're my PR disaster handler. If I'm texting you, you keep that shit between us. If I learn that one of your former clients, you ended up in possession of text messages between you, your employee, and that client, and the employee was employed by you, like part of the agency, right? And I learned that you leaked those text messages. You are fired immediately. Because nothing is going to stop you from leaking mine.
I'm honestly surprised there's not some serious breach of contract stuff, because do they not have an NDA with these companies?
It's pretty shocking to me. I don't know. Has that been raised as a defense in response to the lawsuit by Jones?
I mean, I would 100% have an NDA if, if I was so.
Now, they don't go in the lawsuit, but because they don't mention it, I imagine that the phone itself was company property. Because here the footnote says, while it's not entirely uncommon to request an exiting employee return company property, that's the phone, it is not often the case that personal phones, phone numbers, and communications are seized, made public, and weaponized against the employee and the company's own clients. Personal phones. So I guess it might have been personal phone. I don't know. This comment leaves me wondering whether it was a company phone or not.
Yeah, it's hard to say. I mean, it's her is it her personal number on a company phone? In which case, how dumb is she?
Well, what's interesting about that, not person. So let's say, for example, I've got, our company uses a soft phone, right? We use an IP phone.
Okay.
And IP phones themselves have applications that get installed both on the computer that you work from, and you can install the application on your phone. But in doing so, you just don't grant that application any permissions. The application basically accesses the internet.
Right.
Me installing that application does not give my company authorization to seize my phone, because the company has control over the application. They can seize the data, secure the data that way. But if you have, and people are saying work phones supposedly, but here's read this sentence, because the sentence says, while it's not entirely incumbent to request an exiting employee to return company property, it is not often the case that personal phones, phone numbers, and communications are seized. So that suggests that there was at least one personal device that was seized in this exchange. Now, I don't know the circumstances of that. Seems to me that if you stole my personal phone, somehow claiming that there was company data on it, I'd have a pretty righteous cause of action against you.
Mm-hmm. Well, there is some stuff like they made her sign some things. And so I suspect that it's like, you know, that she may have signed something saying she's got permission to, you know, for them to take this stuff.
Yeah, and plus be mindful there in PR. So client security protection, like client list protection, is a fundamental concern for all of these entities.
Yeah.
So yeah, Apple might not have a claim. It seems weird.
Even just that somebody is a client can be a hotly protected topic.
True.
I mean, you do family law, right? It's the same stuff there, right?
Yeah, we're handling very sensitive information. Like the fact that I represent somebody, I can't divulge. Like I might walk directly across someone's spouse, right? And they might not know that I represent their spouse and we're anticipating a divorce filing, but I would walk past them and I can't divulge to anyone who knows that person that I represent the spouse.
Yeah, because there can absolutely be circumstances where that particular detail is the most protected information you can imagine, right? Spouse is planning to leave could be tremendously, I mean, it could theoretically get somebody killed, right?
It absolutely could get someone killed. It results in disputes over the child where people play capture the flag. It results in violence. It results in theft and damage to property. It results in any number of things. That information is something that I safeguard like you could not believe. If my client has a plan of leaving the house, holy shit, that's one of the things that I don't even disclose that in firm to the extent I don't have to.
Yep.
I let the associate that's handling the case and my paralegal know, because in case some phone call happens, it's urgent. They know to put me directly through. Now, I view this as two separate transactions, though. Did Jones have the ability to seize the phone? That's one question. All right. Assuming that question is yes, did Jones then have the ability, perhaps not the ability, was it appropriate for her to then take the phone, review the messages, probably, review the messages, and then publicly divulge them in favor of one person versus the other when you previously had a contractual obligation to one of the people you're trying to disparage?
And this is one of the things where I'm like, why is that person not in this lawsuit?
I don't know.
Because I would expect that they would be.
And this is a question too, not a question, but Sarah Johnson raised the point, could have had two SIMs. Right now they're eSIMs. So there's eSIMs with these devices. So you can have, I think these phones are now capable of holding up to 2 or 3 eSIM phone numbers. So I was curious about the how the messages came into existence, and this is kind of, we learn it here. On information and belief, Jones's role in the scheme accounts for her conspicuous absence from Lively's retelling of the events. That's a stretch too far for me. Like, you didn't mention her, so clearly she was involved.
I think they're saying basically you didn't mention her because she's involved.
Because she's involved, yeah. That's why she didn't. That's why she's now on the other side of the suit.
Yeah. I mean, I describe this as Hollywood knife fight. And the reason why I describe it that way is because of the old adage that the winner of a knife fight is the person who dies in the ambulance on the way to the hospital, whereas the loser dies on scene.
Yeah.
So this is Hollywood knife fight. Everyone's going to get cut.
Oh, yeah.
And yeah.
In my mind, Baldoni knows that.
I think he does. I think he knows that his career is done.
Oh, he already, yeah.
And he's just like, well, I'm going to burn some things to the ground on the way out. And maybe, I mean, this gives him a chance of having a career after this.
It's a hell of a risk. It's a hell of a dice roll. Because you
Yep.
got to be right. So plaintiffs are informed and believe that defendants have been working in concert since at least August 21st, 2024, when Sloan boasted to Nathan that she had seen the text and Nathan would soon be sued. I would suggest that. So it was Lively that did the smear campaign. Shortly after the film's premiere and the public backlash against Lively, together with her husband, Reynolds, demanded through their talent agency, which also represented Wayfair and Baldoni. How is this not a conflict? How do you get to that place? You are an individual
The
represented
thing
by
is,
this.
they're not subject to the same conflict of interest rules that you or I would be.
I know.
Because if you were, then, there'd be no possibility for that. But
it's just wild that the entity that represents both of these parties here is basically being compelled by one to complain against the other. So demand that Baldoni and plaintiffs publicly apologize for so-called quote mistakes during production in order to deflect the avalanche of negative media coverage. Reynolds and Lively drafted a statement and demanded that Baldoni, Wayfair, and Heath issue that statement, require them to apologize to the public and fall on their sword. Sword. What are we doing, Rob? You can read words. Sword. Sword, despite having done
folks.
Nothing wrong, or else the quote gloves would come off. Again, I don't like these stupid little paraphrase statements. Give me the context in which that statement was made. I have often said that I loved just the public I love the outward, like from outside looking in, the Ryan Reynolds, Blake Lively relationship. They always look so cute. They joked with each other. They portrayed a picture of this wonderful couple that was funny, kind, all of these different things. And I had joked in the past, actually to Mischief, because she loved watching them too, that I would be exceedingly disappointed if that perception turned out to be false. Now, I said this years ago, back when they were first starting to date, and whether they first said, like, these couples so cute, they're so nice, they seem so genuine. Now, all of a sudden, I'm looking at all of this and going, is this really going to ruin what I viewed to be a really great couple? I don't know. I don't think anyone walks out of this thing looking clean.
That's the thing is, the more I learn about Hollywood, the more I think that, like, if you get every good person in Hollywood together, they can, like, share a cab.
You know what's funny about Hollywood? The people that I think I still have the perception of still being decent have all left. Like, they're all like, fuck you guys, I'm out of here.
Who's that?
I don't know.
I mean, if Keanu Reeves turns out to be a bad dude, I'm going to be real sad.
That's one of them. I mean, Lively lives in New York. Keanu Reeves lives in New York. I mean to say that they don't live in Hollywood, but if Keanu Reeves ends up being an asshole, same with Adam Sandler. Everything you hear about Adam Sandler is all positive. Everything you hear about Keanu Reeves is all positive. The funny story I saw about Keanu Reeves, he ran into some couple who was getting married, right? And he went and put on a suit, and they invited him to his wedding. He went and put on a suit and went to the damn wedding.
I've heard stories from, like, Hollywood folks of, like, Keanu Reeves basically and his treatment of like ordinary like sort of the little people on sets.
Yeah,
like
the
you know,
grips.
just yeah. And they're always like incredibly incredibly kind, where it's like, oh yeah, they're so you're like, oh right, this is a guy who's got a reputation within like Hollywood of being nice to the people that like nobody is nice to, because like Hollywood's kind of a terrible place full of terrible people. And it's like, yeah, he's the guy who is so I will be real sad if that turns out not to be true. Like if he turns out to have a bunch of dead bodies in his basement, I'm going to be super unhappy.
Or even if he turns out to be an asshole, I'm going to be really just sad.
Yeah.
Just like if there's a video of him yelling at somebody or you know, shoving someone, I'll be really upset, because Keanu Reeves always just gives me that perception. Same with Adam Sandler. Oh, Jack
I don't know
Black
Adam
lost
Sandler.
that. Jack Black lost that perception. I see this Liam Neeson too. Sandler, Jack Black. Jack Black lost that perception like a couple years ago.
What did he do?
He became very, very stupid. Most notably, he ended up having to cancel his entire tour for Tenacious D for this year after he was making some stupid remarks after a certain attempt was made on the individual that's being inaugurated on Monday.
Yeah. Yeah, no, I remember that too.
Just a boneheaded thing. So I don't know. I'm torn. His bandmate said it. Okay, his bandmate said it. Maybe I'll give him a pass. I don't know. Yeah, all right. If his bandmate said it, maybe I'll give him a pass. I don't know how to read these people anymore. And right now, my perception on all of the Hollywood world has kind of shifted. And
you just kind of assume they're all terrible until and unless.
Assume it until and unless, which is sad. It shouldn't be that way. It just feels like that keeps coming up.
Yeah, no, that's fair.
Apparently I was wrong. It wasn't Jack Black that said it. Apparently it was the bandmate. So I take that part back. I don't hold that against Jack Black for doing that. I know they had to cancel the tour, but it's because his bandmate said it. Someone said it. But either way, back to the lawsuit. The executives acknowledged that in their experience, Lively and Reynolds' threats were not to be taken lightly. They took a stand knowing full well that Lively and Reynolds would bring the full might of celebrity artillery against them, and that is precisely what happened. Lively, working with her husband, publicist Jones, among others, set out on a campaign to tar and feather the plaintiffs in the press. Inspired to work together in concert with the New York Times to put out a blockbuster news report as devastating as it was false. Fabricated narrative. Just as plainly they knew full well their claims were entirely baseless, because their own wrongfully obtained evidence proved that neither the alleged sexual harassment nor the accompanying smear campaign against Lively ever existed. That's reading between the lines of something that we don't have fully articulated yet. This part seemed kind of dumb. I don't know that this really mattered to me. Lively went so far as to serve the lawsuit on the Los Angeles-based defendants as they evacuated their homes in the midst of a devastating fires engulfing their city.
Where's the lawsuit filed, Rob?
It's filed in New York.
Yeah, I was like, they filed it in the wrong place to make this play, because it's a New York City thing, but this is really something to file if it's play in California.
And then they went and said they're really, really bad guys for serving people on these different days. And how would they have known that there was a day that they were gathering kids and pets and preparing go bags? I just don't understand.
They would have. I think that they would have known, in that, everybody was aware of the fires. But at the end of the day, it's like, so Baldoni, if he wanted to be served differently, could have had his counsel send a thing saying, "Hey, we'll accept email service, right? Or please serve, Yeah, I don't know.
I'm not going to say this. I'm going to say in sum, this is not a case about celebrities sniping at each other in the press.
It totally is a case about celebrities sniping each other in the press.
It is. And I will also say that I hate this phrase, and I hate that lawyers included it in there. At bottom, this is not a case. Stop talking about your bottom. Just in sum, the crux of this case is not about celebrities sniping each other in the press. Yes, it is.
See, I've
It's
never
about
heard at bottom before, but at bottom is like that's a sentence that I never want to hear again.
I know. It's like it's like comes now. It just no.
It's way worse than comes now. Cause like
At bottom.
at bottom
Just-
sounds like, you know,
Just why not just say in sum, or why not just say this case is not about you why do you need to do that? Just H Scorpio with the comment that wins. Would at top be better?
no.
No. Leave both of those out of it. This case about two of the most powerful stars in the world deploying their enormous power to steal an entire film right out of the hands of the director and production studio. This is a Then, when the efforts failed to win them the acclaim they believed they so richly deserved, they turned their fury on their chosen scapegoat, tolerating a year and a half of their behavior while remaining polite and professional at every turn, offered Baldoni and Wayfarer no protection. By bringing this complaint, plaintiffs commit themselves to seeking and proving the facts based on not on insinuations built from selectively edited and context-free text snippets. But you kind of did it a little bit, didn't you? Just a little bit, but by putting all the evidence before the court. And then this part's my favorite. And the public. When plaintiffs have their day in court, the jury will recognize that even the most powerful celebrity cannot bend the truth to her will. This part I thought was, while it sounds like it might be like that last sentence wasn't really fought over, and the use of the words in that wasn't really fought over, I imagine that there was several revisions of this, that the most powerful celebrities cannot bend the truth to their will. I imagine this was redrafted a couple different times, and that they ultimately landed on this phrase: the most powerful celebrity cannot bend the truth to her will. Just deliberately bringing it right back to Blake Lively can't control the narrative here. You don't get to bend everyone to your will. I thought that was a clever turn of phrase. Yes, no, maybe so.
I liked it.
Now, the causes of action are at the very bottom.
Yeah, so the question from the chat is, when does the bottom comes now?
No. I also just said that the causes of action are at the bottom. Like, it's just at bottom of the causes of action. It just is so. And whatever happened to brevity? However, here's the thing. When you come into a complaint and you make the comment to me that this is not about celebrities sniping for PR, and you file a 179-page complaint, I do not believe you.
At 179 pages, it's no longer sniping. At that point, it's artillery fire.
At 179 pages, it's a script for a fucking movie. This is the script. And it's not just 100. I mean, we've read litigation before, folks. We have read litigation. Every paragraph, we're on page 104. Every paragraph of this is not one of these very neatly articulated paragraphs. It's a fucking paragraph. It is like 7 sentences, each one of these paragraphs. So this is the after party, right? The after party that he didn't go to, that he was really pissed about, right? And the red carpet. And he posted the photos of everyone having fun. Oh, that's Baldoni's. That's him in there. Yeah.
And it's Baldoni. I love how they're posing on the concession stock, right? The cans of pop. Also, I am being told that we have to break something out for the basement party. This was sent to me by Against the Tide, and it is highly appropriate at times.
Yes.
You know how many people
Yeah.
would give up a testicle to be in that room that he was in?
Yeah.
Like, lots.
Well, and it is about two stars sniping at each other. It's annoying because this is the part that pisses me off when I first pulled up the lawsuit and I got so frustrated I had to stop reading the damn things because it was Lively's lawsuit reads like I am sending a message and protecting all people for all purposes. And I'm like, stop. You're filing a lawsuit against one person. I understand this happens. You are not the banner head for this. You are not the person out there holding the damn, I just said banner, but
Flag?
you're not the banner woman. Flag. I don't know how to say it, but you're not the person that should. This ain't the case, honey. It's not. And we damn well know it's not the case now that there's a contention of multiple narratives. Like there's a time when you bring this up and there's a time when you don't. Causes of action. Oh no, they used that bottom twice.
So they used the bottom twice, huh?
They used the bottom twice. Oh my god.
I'm guessing the bottom was very enthusiastic.
You know what? Lawyers usually have some phrases they can't get rid of. Let's see. At bottom, how many times? Just did Control F. This is how long the fucking lawsuit is. It's taking this long for it to do a search of the words. Oh, they only used it twice, and I just happened to scroll to the 2 times they used it. Damn it. Paragraph 271, which technically speaking is towards the bottom. This case is a simple one. Lively used her power to steal a movie from its director and production studio. Then she held them hostage to her incessant demands by extortionate threats to destroy what they had left. All the while, she failed to understand the heart and soul of the movie she stole and the book it was based on, let alone the intensely personal impact the book had on millions worldwide. When her thoughtless promotions fell flat because they focused on flowery glamour and cross-merchandising opportunities for her own brands, rather than on centering the voices of survivors, she finally got a taste of accountability, and she did not care for it. She made one final demand of plaintiffs that they finally and forever fall on the sword. I did it again.
Rob. All right. I'm gonna go get a sword so that we can.
You would think I've never read anything before. Not like I read hundreds of pages a day. They forever fall on the sword for her by apologizing for things they had not done, killing their future prospects in the process. When they refused, defendants' gloves came off and they used their power and resources to try and take down the plaintiffs for good by coordinating with Jones and Sloan, master practitioners of the dark arts of public relations, in an intricately planned character assassination plot. They nearly pulled it off too. That entire paragraph could have been reduced to a sentence, but they didn't want to. They wanted to say at bottom and sword. Look, that was 272 paragraphs, 168 pages before you get to this line. Usually in every lawsuit we cover, we are usually at the line of parties on page 2. Okay. Fine. I see your sword. I know. Mine's pretty.
Mine works.
True.
Mine is sharp.
True. All right, I'll give you that. But you can't wield that on me. From where you are.
So Rob, you're not coming to Vegas, unfortunately.
Mm-mm.
Yeah,
I imagine, and that was something we haven't told people that yet. Ian is going to Vegas for SHOT Show and the Gundies. Sadly, very sadly, the trial schedule I talked about at the very beginning of this stream does not allow for me to go to Vegas this year.
that is sad.
So I will be there in spirit.
He will.
I will be there in spirit.
I am grabbing the tie so that I don't forget the tie.
Yeah, I will be there in spirit, but I can't be there in person, which is quite sad. But so we go through the plaintiffs. These are all the plaintiffs. It's funny that we are again 169 pages in. We get to the plaintiffs, the parties, the jurisdiction, the venue. Diversity jurisdiction is what we're employing here. Venue is proper because the defendants are there. First cause of action, civil extortion.
I'm sorry, I shouldn't laugh.
I mean, holy shit. They think they can prove this?
No, they don't. The thing, like my video on this starts with, they're suing for $400 million. Why are they suing for $400 million? So that I will say $400 million in the video I do about it. And so that other media will say $400 million. That's also why they're suing for civil extortion, is so that we will say the word civil extortion and people will think, oh, that's totally a thing that he's gonna. And no, I don't think he's gonna. Yeah. I don't think that that's actually going to be a thing.
Now, it is funny that they're trying to throw Lively's words back at her. They're like, Lively, you sued us in New York. Like, you sued us in New York. But then you said that California law applies. So we're going to go ahead and say, fine, you want California law? Civil extortion. Defendants made threats to plaintiffs that they knew to be wrongful, including threats to breach contracts, defame plaintiffs, and injure. Defendants. Whoop. That was intended to not stop there.
Nope. It just, that sentence just, yeah.
Well, the extortion was so effective, it prevented the sentence from continuing.
Yeah, that I thought that was, it's like, oh, proofreading is not a thing we're doing anymore, is it?
No, but you write 179 pages and you this is why a 50-page complaint, very well written, could have sufficed. Defendants' threats included demands that money, property, services, and other sources of value be conferred upon defendants without. Another typo. Oh yeah, no, it's not. Defendants without consideration of contractual entitlement. That's right. My brain. I was thinking conferred by plaintiffs upon defendants. Plaintiffs complied with all the wrongful demands. Plaintiffs were harmed. Defendants' wrongful threats and demands were a substantial factor in causing harm. On information and belief, each of the defendants was aware that the others plan to commit, so they're doing conspiracy so that they can all be held liable. This is not going to survive motion to dismiss.
No.
They're going to have to actually have evidence of the conspiracy in order to maintain liability against any one of them. And they're going to have to do it now. I don't even think they get the discovery on this one yet, unless you can actually affirmatively allege facts sufficient that would give plausibility to the claim that they know. And you have to affirmatively allege it.
It's not designed to survive it's just designed to be a claim. Like, it's designed for us to talk about it. So,
Second cause of action, defamation. It's New York. It's New York. All of these defamation lawsuits are taking place in places that do not do defamation lawsuits.
at least not easily.
Not easily. Now, if this were Florida, where CNN just got hit for defamation and a $5 million judgment and an undisclosed settlement on punitive damages, then that might be different. But this is New York.
Yeah,
So-
I mean, that one I'm just like, yeah.
I mean, problem is that opens up by alleging defamation here. That at least makes the entire process of litigation 3 times as long, because you now have all the anti-SLAPP that comes in that gets separately litigated beforehand, and the anti-SLAPP litigation occurs before discovery, which is frustrating. It's like you know the lawyers sat there and had a conversation with him and were saying, can we not do the defamation and stick with the other parts so we can get straight to discovery?
And the answer is no.
Yeah, he said no. And for those who have never heard the term anti-SLAPP, anti-SLAPP is anti-salacious litigation against public persons. It's an additional hurdle that you have to clear to keep bullshit complaints out, to keep people from speaking in public.
Strategic litigation against
strategic
public
litigation. Sorry, strategic,
participation.
not salacious, not salacious.
Yeah.
Strategic litigation.
Yeah.
Yeah. Statements made by defendants intended to cause harm. I mean, I don't know. This count, I don't have a whole lot of faith in. False light, invasion of privacy. The false light created by the disclosure of the defendant would be highly offensive and objectionable to a reasonable person in plaintiff's position if made in that it made Baldoni, Heath, Nathan, and objects of scorn, pity, ridicule, humiliation, and often suffering.
Now, I feel like he was that beforehand, but
I don't know. That's going very far. Breach of implied covenant of good faith and fair dealing. Dude, you're now doing implied good faith implication.
I mean, there is an implied.
There is because they're both.
Because they're in a contract.
Yep.
It is a thing, right?
I actually, and then with this one, I see it with they're both. There's an implication that both of you are going to engage in behavior that's going to result in your mutual prosper, especially because of the fact that you contracted with each other and with the film company.
Yeah.
So you both engaged in this with the implied implication that you would both be acting to maximize financial gain to the contract as a whole, to all parties to the contract.
Yep.
I get it. That part, I can see that. If you tank the film intentionally, but the thing is, you have to demonstrate that. I think you run into the issue with the damages claim here.
Or it's not just if they tank the film intentionally, but it's also if they take the value of the film.
Yeah.
Like, if you make a deal with so-and-so that you're both going to work together to, sell widgets.
And they're they're going back to the, they're roping that into the extortion part because they're trying to make the claim that she put herself in this producer role, which had the added benefit that was conferred to her because of the extortion and the behavior. I get it. Okay. Intentional interference with the contract. Yeah, I figured that was coming. Now that's just the third parties. You can't You can't allege someone for intentionally interfering with a contract that you have and you're in with that person. You can allege against third parties. And this is as the contractual relationship between the studio and Baldoni. Sixth, respective economic advantage. You get one or both. You get one or the other. You don't get both, in my experience. You can have intentional interference with contract, but you can't have economic advantage, business expectancy. You are limited to one course of damage.
I think that they would probably get a jury instruction saying, listen, the
These
damage isn't
alternative.
going to get doubled.
Negligent interference. All right. So this is not two Hollywood stars just doing this as a pissing match. The knife fight thing is a pretty accurate synopsis.
Right?
I mean, it's almost also like throwing a grenade in a room and then walking into the room. Like you're assuring destruction of the other side, but kind of assuring your own destruction too.
Yep. Everybody gets a knife fight, or everybody's going to get stabbed.
Look under your chairs. Everyone look under your chairs right now. You've got a knife. You've got a knife. You've got a knife. You've got
everybody's
defamation.
getting
You've got
stabbed.
defamation. We're all yelling at each other. We all did the wrong thing.
And everyone's getting stabbed.
Just, oh, what a mess. What a mess. Soap API, Runkle, footnote, fire.
Yeah, he's got some great footnotes. Like the footnotes of,
really?
Hey, I'm going to try to find the pages.
I'm going to find one. Fine. Because there was a couple at the top that looked pretty good. At top.
There's little places where he drops like quiet footnotes that I'm just like, oh, that footnote is a whole lot of damage.
Well, he did one in the beginning or towards the beginning.
Page 8 has a wonderful footnote.
We read that one.
And that one is basically like, oh, by the way, your company sucks because you turned against your own people. That was a whole thing.
There's a footnote saying, stunningly, later in the process, Lively refused the opportunity to meet with No More, so she refused to meet with them. But that doesn't have any receipts. Let's see. What's another one? Page 20 has a footnote.
I'm looking for the one I really liked. The one that was just like, oh, that one's a whole lot of damage.
This one's funny.
I like the one on the bottom of page 34.
Okay, hang on. Let me pull the one up on page 20 because the one on page 20 made me laugh too. Because page 20, when you reach this level of text, this is no longer a footnote. This is a paragraph. This is. So
oh yeah.
Where's 6? So the comment here: on the first day of principal photography, paparazzi captured and published photos of Lively in character wearing her hand-picked wardrobe. These images were widely reported as unflattering and sparked backlash from Sony. So what's the footnote there? Notably, Lively herself had voiced insecurities about public perception of her casting as Lily Bloom. Lily is described as a 23-year-old young woman and recent college graduate within the first few pages of the book, which Lively would have known had she read the book before production, despite having admitted to ordering a copy months before, which remarkably she ordered only after she had already committed to the role on December 20th, 2022. All right, that's not as spicy. Nevertheless, when Lively learned that Lily was a decade plus younger than herself in the book, oh shit, you went after Lively's age? Mm-hmm. Lively asked the author Colleen Hoover explained in her public casting announcement that they had decided to age up the book's characters for the film. Hoover didn't put the statement out in the way Lively requested. Lively was not happy. Oh, they aged you. Oh no. You said page 34?
34 is one.
Oh, hang on. Where is it? So Lively continued to express her warm appreciation and respect for Baldoni as filming continued, even as she acknowledged she could be difficult and critical of others, using the kind of language she herself would have alleged to be inappropriate. Justin Baldoni to Blake Lively. I'm not going to tell you that you were amazing because you teased me for being so sentimental, but you were amazing today. Blake, thank you. I do appreciate it. I'm just a ball buster, but it means a lot to me. I care a great deal and always want to deliver. You were terrific. I'm very proud of everything we did today, but really every day. Lively's use of the word ball buster would certainly have made it in their 17-page list that had been Baldoni who said it. That's two things.
That is
are said by
excellent
that.
snark.
And it's two things. One, the rest of the text message exchange demonstrates how they use language with each other and the fact that they were supportive of each other. Two, it makes the second point of if Baldoni had said ball buster, you can believe it would have been there.
The other thing I'm just going to note here is look at the one on 36. 36 has got an excellent that was the one that I thought was
this one.
bomb.
Okay. Yeah. Lively herself set the tone for the personal discussions on set, including what language is acceptable. For example, on one occasion while filming a restaurant scene, Lively sat on the floor in painfully expensive shoes while discussing with a group of male cast and crew how, quote, sexy her shoes were. Footnote. This is evidenced in film footage captured between scene takes.
This is my favorite little thing. And the reason why is because it's like, did you forget that I have the recordings? Because she says that there's no recordings of this, right? She says that there was no audio, and he's like,
cameras.
I have the tapes. I have the tapes.
Yeah, because he's saying, you know, we did away with this generation of needing to switch the films over. We actually could afford to roll full time and do markers in between.
When he says I've got the tapes, that is a very badass, very quiet, very understated, but very badass little footnote.
Here's the other one. Oh, wow. So this one, if true, and I have no reason to believe it's not, while Baldoni and Wayfarer clearly agreed that coworkers should respect physical space, Lively's constant confusion of references to her character as played by Lively, as opposed to Lively herself, became problematic and interfered with production. This was caused in large part by Lively's persistent desire to direct and inability to accept direction. For example, her allegation that Baldoni inappropriately called her sexy was in fact a reference to a scene where everyone was wearing onesies, but Lively was covering her onesie with a big coat. Baldoni, her director, asked that she take off the big coat so that her onesie could be visible in the scene. Baldoni said it will be hot, as in it was 90 degrees in the small bar with no air conditioning. Lively mischaracterized this in her complaint as Baldoni referring to her personally as hot. This, by the way, I will read the footnote when we get to the end of the paragraph. Given that Lively herself had earlier expressed to him that she wanted her character's wardrobe to be sexier, Baldoni encouraged her to accept direction by saying, it's sexy, meaning that without the big coat, the wardrobe was sexier, as Lively had said she wanted it to be. Lively took this personally. She's unable to take the direction. Self-chose a wardrobe. That's not what I'm going for. Baldoni recognized that she may have taken this direction personally and appeared offended. Apologized more than once. His statements were immediately followed by his gesture that she had something in her teeth and a request for someone to get her a toothpick. This exchange, all of which is captured on camera.
He's like, do you think I was saying how sexy you were when I was also telling you that you've got like an entire salad stuck in your face?
And deliberately malicious Lively's allegations are. Yes, if the role and if the moment calls for you to be acting sexy and the director says, I'm sorry, you need to be sexy, that's direction. And if that's on camera, because the entire exchange, that entire paragraph, right? If you remember, we talked about I've made the comment. If I give me your phone and I can make you a monster or a saint based on the text message and how I read them.
Mm-hmm.
You know what doesn't allow that? Video. So that's going to be interesting. And it's nice that the lawsuit makes it very clear there's video of this. Because video would add a whole lot of context to that discussion.
Yep.
Okay, so playing a little bit of catch up here. So I want to get to the last topic briefly. And if that's the case, this is going to be the most
If you don't get to
content-filled-
Diddy, I think that the chat is going to murder you.
Shoot, yeah, they'd be terrible. They'd be very upset. Sir Black used to make a medieval grab with fanny fabric. Okay.
Garb.
That's a grab. Talking about lawsuit, sexual harassment. I'm sorry. Yeah, thanks for becoming a member. Canonical Heat. Where did the time go? Thanks for good time and for the knowledge. 23 months as being a member. Thank you, Canonical Heat. And Canonical Heat, thank you for the gifted memberships. Very kind of you. Marmar, taking over my cow's case. Big hooves to fill. Marmar, glad to see you here.
Give
Very
him hell.
glad to see you here. Give him hell. Best of luck. It made me sad for a second. So I hope you're doing well, Marmar. I very much hope you're doing well. Fight like hell. Don't stop fighting. Tiamo Lisa. Oh, yes, it has been a while. 28 months. Tiamo Lisa. Thank you. Sandy gifting memberships. Torin coming in as a plus. My Delta 3D printer has been printing out shop tool drawer cabinets for the last 2 weeks, and new motherboard for Fed streaming computer comes Saturday. Those are 2 positives. Now, keep your hand away from the router, like the spinny router.
Routers are, yeah. If you find a woodworker who is missing a finger, it is entirely possible that it was a router that ate
It's
it.
usually one of 3 tools. It's a jointer, a router, or a table saw. Narcissistic, as easily as they come for TikTok, YouTube could be next. It could be. I think you have very different structure and concerns, but it could be. AG celebrating 8 pounds down in 5 weeks. Happy to be here. Congratulations, AG. Way to go. Joy W, is Benchy one of the Bad Dragon copyright claims? No. At bottom, I would say it's not. Jeremy Morton, what's the definition of derivative in CC license? Collective comments.
I mean, it's just the same as derivative for anything else.
Same as derivative works. It's creating something or doing something transformative so that it loses its original and becomes a new piece of work, new artwork, new piece. Krista, sending lots of love and light to everyone. Heart, Lawn Lumber, and Runkle. Thank you, Krista. Very kind of you. Our Bauer, 1 more month until our second YouTube baby. Congrats. Lynn Britton, we started out with adult toys, then at bottom comes now, and now sword fight. Holy moly, what an F and F. This is what happens. It just does. Unfortunately, now we're talking about Diddy. And there will be a lot of sass. Radio Man, my mom's sister didn't like the auntie slap. No, she might slap your ass back. Auntie slap hard. Equality, thank you for gifting memberships. Equality, very good to see you here. I got my exam results today and I passed with distinction. Equality. Very amazing. Congratulations to you with distinction. My distinct congratulations, rather. Quinny Bly, just because you guys are awesome. Me and I keep missing no lives. Hugs to you both, mods and chat. Thank you, Quinny Bly. Glad to see you here. Marley R, I'm about 3 hours behind. Plus, don't forget about Jeff. Megan, Flex, and others are traveling to Utah for his services. We will
I
keep
wish
Jeff
I could. I can't.
Our thoughts and prayers. absolutely will be keeping him in our thoughts and prayers. Aya, what printer did you buy? I've been wanting one. The Bamboo X1C. And I did all the different thought processes on it. And I know the concerns with some of the software. I reviewed all the terms of service and what they can access. I'm happy with it. And it's remarkable what Bamboo has done to the industry. I also, Mischief's definitely asleep right now, right?
Yes.
Yeah, it's 12:38. I also have a Prusa Core 1 that's on its way. It's just delayed in shipment. But the Prusa Core 1, I think I'm going to keep at the office so that it's not visible.
I am going to talk to an expert at SHOT Show about 3D printing.
I know you are.
You know who that is, right?
I do know who you're talking about. You can tell said expert that my printer prints carbon fiber reinforced nylon.
Oh, nice.
Bop it. It's nice to make an F&F. Glad to have you here, Bop it. Haven't seen your name in a bit. Glad to see you. Robin Day, fighting insurance about a 3D printed prosthetic leg cover. If I lose, my nephew's going to look for a plan. Maybe a Benchy cover. Maybe a Benchy cover. Okay. We have made it through. And yes, to all of those guessing that I'm keeping the office so I don't get busted. Yes, you guys are absolutely right. I'm keeping the office so I don't get busted. Don't freaking tattle on me, okay? Just don't do it.
You know, I have a fiduciary duty to.
No, you do. You absolutely do not. You absolutely do not. So there's not enough space down here, and my logic is my logic. So I'm sticking with my logic, and it doesn't hurt anyone. It's in my office. I need something to tinker with while I'm working. It will make me happy.
I'm going to see at SHOT Show if anyone has any massive Nerf weapons.
Yeah.
By the way, how goes the planning?
Hate you.
You're like, shut up.
I hate you. I need a wedding planner. That's what I need.
I mean, I'll do it, but you won't like it.
I mean, I probably wouldn't mind. It would probably be married, cool. Drinks and bar, everyone has cocktails.
That's pretty much it. You're Catholic, right? So there's got to be like a yeah.
There's stuff involved, but we'll figure that part out. Okay, let me swoop. Let's get to Diddy because Diddy is the last topic and we need to cover Diddy. Diddy took a very interesting tack this week. I mean, there are decisions. Sean Diddy Combs' legal team says the freak off videos don't show sex trafficking. Okay. Hip Hop Star's attorney says that they were shown videos that prosecutors plan to use as evidence, but that the tapes don't depict any illegal activity. Here's the problem with sentence 2 or the subheadline. There was a protective order in place. It was pretty explicit on what could be shared. I don't know that this was permissible.
Wait, he didn't share the videos, did he?
No, he didn't share the videos. But the question is, by referencing the videos themselves, referencing the contents of the videos, could that tangentially be viewed as walking pretty close to a line here? Sean Diddy Combs is fighting back against evidence prosecutors are expected to use against him in his criminal trial in New York in May. I cannot believe that trial is going to be in May. If that thing goes forward in May, that is going to be wild. So his attorneys say in a filing that they've reviewed the 9 videos of the so-called freak-off tapes provided by prosecutors regarding the person referred to as victim 1. Filing seeks to obtain electronic copies of the videos, which Holmes' attorneys say confirm Mr. Holmes' innocence between fully consenting adults in a long-term relationship, which gives you a suggestion as to who victim number 1 is. Is it Cassie Ventura? It's got to be. Source with knowledge of the case says Combs' legal team can view the videos only in the presence of a government representative and can see them but cannot keep them. For very, very, I mean, do we not remember Sam Bankman-Fried and what happened when he got access to materials? And the concern. Document also says the recordings were not part of the raids conducted on Combs' properties last year, but were kept by victim 1 and provided the government as part of its criminal investigation. Okay, let's go to the documents then. Let's just figure out what the documents actually say. Dear Judge, we write on behalf of our client, Sean Combs, to request a modification of the terms of protective order to require the government to electronically produce videos described in paragraphs 12A and 12C of the indictment. Footnote. The protective order requires the parties to meet and confer regarding any dispute over the government's designations, after which defense may seek to de-designation by the court. We have conferred with the government who opposed this request. Okay, at least we know we're fighting. The protective order includes a novel provision making this video evidence available for inspection only and not electronically produced. Funny thing about that is the reason why a lot of this stuff can't be electronically produced is because sometimes
They don't want it leaking.
We don't trust individuals in the team. Not your lawyers per se, but let's say.
But also the lawyers.
Yeah. And let's say hypothetically that someone, one of Diddy's trusted friends, pulls out their cell phone while the lawyer is viewing it, starts recording it, and leaks a copy of a copy.
Well, and the other thing is, if they really wanted this leaked, you could see things like, "Oh, right, we're firing our assistant because this got out," and suddenly the assistant like moves to a private island somewhere. It's like, yeah.
The other concern about this is that the videos, we'll keep reading. Having reviewed the videos, is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. Rule 16A1E expressly requires production of copies of such materials to the defense, and there's no plausible, quote, good cause to restrict access to them under Rule 16D1. I can think of a couple of things that I would consider cause. For example, what the videos depict, who's the owner of the video. I mean, and then
I don't think this is going to turn into a copyright claim.
No, but in what fashion is the video being produced to you? Produced so that you can visually inspect and, proffer me an expert that's going to take a look at it. I can produce it to them. I don't know. I see both sides of this. I think that the defense has a good argument that they actually should get the actual file. Oh, KP. Yeah, I know. I realize that. Yeah. Yeah. I'm torn on this one. Accordingly, they should be produced in the normal course so the defense may evaluate and use them in the same manner as the other Rule 16 and Brady material. Check something. Oh no, there's an article about Blake Lively responding. It's another chapter in the abuser's handbook. Sure. What's the case number? It is CR 07552. Just want to check, make sure I have the right document. Do. Okay, 129 is still the publicly available one. 126 was the one that got deleted. All right. Redacted, that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called, quote, freak-offs were private consensual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes film their sexual activity. Whole lot of redacted. These recordings corroborate what witnesses have told the government, namely that victim 1, redacted. These recordings also directly refute the allegation that Mr. Combs kept these videos as collateral, redacted. I don't know. Moreover, contrary to the innumerable sensationalistic media reports, the videos do not depict sex parties. They are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no mirrors, and redacted.
No tunnels? No minors? Minors is different than mirrors, but no tunnels? Who said tunnels?
Far from the government's lurid descriptions, redacted. Oh no, this lawyer does it too. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs, followed by redacted.
Do not ever at bottom.
Especially in this fucking case.
Or a non-fucking case either.
Well, yeah, I realized that phrase was probably incorrectly chosen. Soon after Combs was charged, the parties began negotiating terms of a protective order. During the negotiations, the government insisted over defense objection that certain videos obtained from victim 1 and depicting alleged freak-offs would not be electronically produced and would instead only be available for in-person viewing while monitored by law enforcement. Government explained that victim 1, whose attorney gave the videos to the government, requested that they not be produced to protect her privacy, and the government would honor that request. Oh, that part. She's still a Doe. She's still a John Doe or a Jane Doe.
Doe, a deer.
A female deer, Ray. To ensure that we would receive discovery without further delay, the defense agreed to receive the discovery under those circumstances or conditions, while reserving the right to propose order to later seek modifications designations. After spending 4 weeks attempting to schedule viewing of the evidence, the defense was finally able to watch the videos under supervision of law enforcement on November 20th, 2024 and December 13th, 2024. They redacted everything except a reference to footnote 3, but footnote 3 is redacted. And apparently a space between a period and the beginning of another sentence. So there are 3 sentences depicted, all of which are redacted. There's no evidence of any violence, coercion, threats, or manipulation whatsoever. There's no evidence that anyone is incapacitated or under any influence of drugs or excessive alcohol consumption. There's certainly no evidence of sex trafficking. But is there evidence of her identity, which is still confidential, and which the judge has already indicated in holding Combs in detention that he's concerned about leaked information? Rule 16 requires electronic production of videos, and there is no good cause to withhold production.
I feel like there is.
I'm waiting for the government response to this because we have it. I haven't read it yet, but I imagine the government's going to have some pretty contentious statements as to good cause. Freak-off activity is the core of the case. These videos are unquestionably material. Blah, blah, blah. The court's authority to enter order to modify protective order stems from Rule 16d1, which provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection or grant it any other appropriate relief. Demonstrate good cause. So if you want the protective order, you have to demonstrate good cause as to why. Party can demonstrate good cause for the issuance of protective order only, or when a party shows that disclosure will result in clearly defined, specific, and serious injury, such as compromising the privacy interests of innocent third parties. There it is.
Yep, we got our good cause.
Or impeding ongoing investigations. I think there might be there. Government can't meet its burden. There's no good cause to prevent the electronic production of these highly exculpatory videos. I love that they say it's exculpatory, like they're making that assertion.
Yeah, I don't think the government would agree that it's exculpatory.
I imagine that if you were to, for example, edit that video in some capacity and show part of it but not all of it, might seem exculpatory. Moreover, any concerns regarding victim one's privacy interests are adequately protected by the remaining provisions of the protective order. I think the government's going to think they're not protected.
I mean, every jackass on the planet is going to be trying to hack that, hack their, their systems. So
then there's their argument for the attorney's eyes only. And this part shall not be possessed by the defendant except the presence of the defense counsel. One of the challenges that I have always been concerned of is third-party recording in that instance. How do I know that an agent of my client, not just my client, but my client's bodyguard, family, people that my client has insisted on being in meetings, is not doing something stupid?
they're always doing something stupid.
This part is persuasive to me. They need to use experts. Enhance the quality of the video and audio. Yep, that's a good argument. And analyze the metadata. That's a very good argument. So that would suggest to me that the expert has to have the ability to access the electronic file. The government has offered to use a neutral expert to enhance the video. Nope. I'm not buying this argument from the government.
No.
Neutral.
There is no such thing as a neutral expert hired by the government.
No. All right. So what's the caveat? What's the carve out? I think it goes maybe attorney's eyes only with expert.
Expert can see it at the government office.
Expert can analyze material at the government office, like a SCIF, like that. But we're not going to give you a forensic copy of it. Like you can do all your analysis. But that
we'll
would
give
be
you a clean
the
computer with a forensic copy on it. You can analyze it there, but you can't analyze it at your office.
That's in Law B. That's what we're talking about. The methods of giving access, but not copies. And that's what we're talking about. We will put a forensic image of this on a computer. You tell us what software you use to analyze. You tell us what software you want to use to analyze, and we'll allow for that software to be installed on this. Hell, we'll install it ourselves. And you can analyze all of it. It's troubling the government's had this evidence since December of 2023 and nonetheless brought these charges. Well, that's because I think the government thinks it shows something that you don't. The video evidence refutes the claim that victim one was forced to participate and can only be squared with her account if one assumes, as the government apparently does, that certain women cannot consent despite all indications to the contrary. Well, here's one of the contentions that I think the government might be raising. is that when a person is in an inhibited state, and the inhibited state happens to be caused by consumption of certain things that they might have consumed involuntarily, then no, they can't consent, even if the video depicts them doing all types of actions that might suggest consent. Interesting. The government's view also depends on characterization of free costs as dirty, disgusting, or inherently unsavory, and therefore must have involved some amount of coercion. I love that everyone's now just happy with this word free costs. Not happy with it.
I wouldn't say I'm happy with it.
That shows, yeah, I get it. Like, but we've all just adopted this word of free costs. Like, this actually now has some meaning that we're supposed to understand.
It means basically put a flamethrower through the mail slot and run it until the gas tank is empty.
Any fair-minded viewer of the videos will quickly conclude that the prosecution of Mr. Combs is both sexist and puritanical. It's sexist because the government's theory perpetuates stereotypes of female victimhood and lack of agency. The prosecution reflects a paternalistic view that the government is here to protect women, who cannot be trusted to make their own decisions about sex and are not capable of consenting to sex that the prosecutors view as outside the norm. Well, here's the thing, Mr. Attorney, Mr. Counsel, this is an argument you make only to a judge, because holy shit, if you make this argument in front of a jury, I mean, wow. This is some light treading. These videos, redacted, and fundamentally undermine the government's case in victim one's claims. Indeed, they are entirely consistent with redacted. They are unquestionably Brady material, notwithstanding the government's outlandish theories, and we anticipate. I'm giving you Brady. I get it. You get access to them. I don't know that you get them. Protective order to be modified to allow electronic documents. Okay. So, Mr. Government, how do you respond? Or Ms. Government? Government request to amend the protective order. The government respectfully submits this letter to the court, that the court direct that the defendant's January 14th letter motion to amend protective order be removed from the docket and refiled with the appropriate redactions that comport with the requirements of protective order of the case. Ruh-roh. You did a bad, and now you wonder why we don't want you to have the video. You filed that letter unredacted. Naughty, naughty. And you filed a motion asking for the video to be disclosed, and you filed it in unredacted format. And you wonder why we don't want to give it to you. The motion seeks an amendment to the protective order related to certain videos that have been made available to counsel and the defendant for inspection only and not electronically produced. In making this motion with incomplete redactions, however, the defendant has violated the protective order he seeks to amend. Videos which depict sexually explicit content and nudity are designated attorney's eyes only by the protective order, subject to the carve-out of making videos available for defense inspection. Footnote 3, which is redacted in the publicly filed version, specifically addresses how the videos will be made available for inspection. All visual depictions of sexually explicit content or nudity will be designated AEO, attorney's eyes only, regardless of whether it's been designated as such by the government. At the discretion of the government, certain AEO material depicting sexual explicit content or nudity may be made available for in-person inspection only. Protective order makes clear that the defense shall not share any AEO material or the content of AEO material with any other persons, subject to the carve-out allowing for a defendant's inspection of the videos. Further, that material is also designated sealed under the protective order, meaning that any portion of such material cannot be publicly filed on the docket unless it is filed under seal or the parties first confer regarding the seal designations. No portion of the video should have been filed on the public docket without being filed under seal. Neither occurred. Instead of conferring in advance or redacting all content related to the videos, The motion blatantly violated protective order when it left unredacted descriptions and characterizations of material designated attorney's eyes only. There's no alternative reading of the protective order other than substance of AEO material cannot be shared with any other persons, and AEO material is otherwise designated sealed. Dude, judge is going to be pissed. This judge is going to be fucking pissed. Judges hate this. Because this gets perceived as an attorney, as playing PR.
Because that's exactly what it is.
That judge is going to be real fucking mad.
Some lawyers getting invited to a freak off.
Oh
That's
my
how mad
God.
the judge
And
is going to be.
And here's the problem, because it's Pacer. Oh my God, it's so much worse. Oh, fuck. So because it's Pacer, there are certain spiders, and by spiders I mean internet crawlers, that pick up and download
And save it forever.
Which includes this unredacted letter. I know, because
Oh, yeah.
looking at it.
You're not fixing this.
No, I'm sitting here looking at it right now. Wow. Okay. This is pretty horrible.
Hmm?
Have you read the unredacted letter yet?
I have not.
I'm going to drop it to you in the private chat so you can read it privately. And no, chat, I'm not going to read it to you guys or give it to you because I'm not going to feed this fucking ammunition. Suffice it to say, they describe conduct that's engaged in the videos and the number of videos, and they describe what individuals that are participating in said conduct might be feeling about the conduct that's being engaged in.
Oh, that's a hell of a choice.
And how that it's being reflected in the videos. That is the part that was left unredacted, that because I just read through that letter. I know it was redacted or not redacted, but that was stupid.
Apparently, EDB streamed it and it's still up there. So, yeah, that's. I don't know if she's aware.
Well, apparently it was up for hours. Hours. You know how long hours is in a public filing like this?
Oh, I mean, if it's a public filing that is like, nobody cares, whatever. If it's a public filing that is, this public filing, yeah.
That's a fucking choice. Suffice it to say, the suggestion that one of the participants in the video was very much enjoying the behavior.
The version that you sent still has redactions. I don't know if it.
No, but the redactions are not the same.
So it has insufficient redactions, not
insufficient
no
redactions, not no redactions.
Gotcha.
Court, the government therefore requests that the court remove the motion from the ECF with direct counsel to refile. The redactions that comply with the protective order of this motion, the government also resubmits the under seal for the court's review proposed redactions that comply with the protective order After the motion was filed, the government immediately contacted the defense counsel requesting that additional redactions be made in accordance with the protective order, and counsel responded only that they disagreed with the government's view of the protective order. Oh. Oh.
Yeah, if there's any disagreement on that, you get that to resolve by a judge, not by just going ahead and putting it in the public.
That's I'm not going to put up the unredacted. So here's what you have. You have the and here's the other part of how you know the judge is pissed. Granted. Just a memo line, granted. Clerk of the court is directed to strike the motion at docket 126 from the public docket and terminate the motion at 127. Counsel should refile the motion with the appropriate redaction. If defense counsel refiles the motion, the government may respond by January 28, 2025. That is, the judge has read what you are saying you disagreed with, and the judge says, no, refile your shit.
And the thing is that the judge could have gone further, because the judge could theoretically have said, yeah, I am tossing this and I'm not giving you permission to refile.
So let me pull, I'm reviewing for my own benefit the difference in the two so that I can see and I can describe it to you. I'm not going to pull it up, so I don't want to highlight it any further. Docket 126 and 127. $126. So let me see. Let me go back to this one that was the proper one. The one that was the original, right? All counsel via ECF. They talk about the number of videos, which you shouldn't be identifying how many videos there are if you're referring to the contents of it. Wow. Yep. Describes what the victim perceived of the conduct engaged in during the video taking place. It says where the videos were obtained from and that they were not from the defendant. Purports to say what the videos depict. This is a lot that just got left in there.
Mm-hmm.
Wow. You know what? If you are Sean Combs, well, we know what his defense is going to be. Consent. Okay, that part's fine. No problem with that. All right. So it's a characterization of the conduct that it's a characterization of the people, of the experiences that people characterizing the experiences of the individuals that were on the video were having in a public filing. And now you can see why maybe they don't want that happening in public filings.
Mm-hmm. Because it's wildly inappropriate to be in a public filing.
Mm-hmm. It's just, yeah. So that was a choice. So the government has until the 28th to file a response. I think that government response is going to be,
Two words.
Just hang on to your socks. Let's get, they're going to come in swinging. Holy crap.
Mm-hmm.
This is going to be very interesting to watch. All right. That was a decision that Sean Combs made. Did he? That was not smart. That was not smart.
I mean, it might have just been his counsel's decision, but
yeah. But if he put into writing, if that is in writing an email that's saying we have differences of opinion on what the order requires, that's a challenge right there. I'll tell you that. So, all right, let's catch up on Super Chats. Get out of here. It's 1:13 a.m. my time, which means it is time for us to wrap this show. Katrina Turner at 51. I still have all my fingers. Just don't ask how many carving tools have ended up stuck in my hand, arm, or leg. Every injury I have received in the shop has been from a hand tool. Every one. Whether it's a chisel, a saw, or something. It's always been a hand tool. And I feel lucky, but unlucky for that too. Marianne Froning, YouTube is an American company and banned in China. And China's allowed to ban it. Elise Charlene Fine Art, what do you think about the iTool M1 Ultra 3D printer? I don't know. Honestly, that's a very, very specific model in question. I don't know. I boiled mine down to Prusa and bamboo. Those were the final two top runners in my book, but I know that Chidi has good ones too. Lauren Ellie, PS from the newest Neurospicy commissioner for taking affidavits. Oh, awesome. Court reporter.
Congratulations.
Thank you for making the law engaging and accessible. Baby steps. I'm glad you have found it that way. Joshua, thanks again for a great FNF. Thank you very much, Joshua. Have a wonderful weekend, everyone. Thank you, Joshua. Chrissy, did I hear right last week that you are a Justice Alito fan? Please elaborate. No, I'm a Gorsuch fan. I think Alito can be a little bit... he picks lines of attack I don't always agree with. Sometimes yes, sometimes no. Equality, Jeff's passing taught me how important it is to tell everyone you love, including parasocial internet relationship, that you love them. Just want to say I love you guys. Anyhow, nighty-night, everyone. Thank you, Equality. It's very kind of you. And
good night, Equality, and likewise.
Yeah. Katja the Frankfurter, thank you, Robin, Ian, and Kurt, moderators in chat, for keeping me company during mentally challenging times. Have a wonderful weekend, everyone. Have a wonderful weekend, Katja. There are challenging times that we all face, and hopefully we can get through them without too much wear on the old bones, brain, heart, and mind. Rency Lou Who, thank you for becoming a member. With that, folks, I wish you all a very happy weekend. I hope that you get outside, get indoors, do whatever you got to do, go make something. You will feel better. I absolutely promise you, proven by the 3D printing stuff. Ian, thank you for being here. Very safe travels to you as you attend SHOT Show.
The roads were pretty exciting on the way there.
Oh.
Have you ever driven in like really fierce blowing snow?
Like once, and I don't know that you and I would qualify them as the same, given the depth of snow that might be on the ground.
If you can see the lanes in the road, then because I couldn't.
Oh, I've been there.
We're taking the dogs to drive, and it's just like, well, I hope everyone else is driving the right direction, because yeah,
it gets really sketchy, especially when the demarcation of the road and the other terrain, like the fields or the grass, is just not visible.
Yep. It's like, if I feel grass, turn the other way. So
why don't you fill people in on what you're doing real quick? I need a quick break.
So I am going to Vegas for the Gundies, and the Gundy, well, and SHOT Show. The Gundies is an award thing. I have won a Gundy. it looks like this. So yeah, what is it? But SHOT Show is a big firearms convention, so everyone, it'll be seeing all the new things in guns, including including going to the industry range night and shooting some of them. So that'll be fun. So yeah, that's kind of the game plan, is go and see what's going down, and yeah, it should be exciting. I hope to. I see some people saying, "Is the Gundy streamed this year?" I don't know. You'll have to check their webpage.
They
I am also
more recently they've been filming it and then releasing it days after or a day after.
I am also I'm gonna do a meetup on the 23rd. I don't know where yet. I'm gonna go and try to do some recon to figure that out. But yeah, we're gonna see about that. So yeah.
Chat's asking, assuming that there's going to be no Monday.
No Monday. No, I posted that to Twitter. I should post that to YouTube as well. Just to let people know I'm going to be at the Gundies for that. So I cannot. So yeah.
Yeah. And then questions being asked about FNF next week. I don't know. My trial docket is scary. So it's going to be a to be determined.
I'm also, if Rob will allow, going to drop a link in the chat. And so I'm just pulling it up here. So I'm also trying to win a thing called a bunkie. So this is, I just bought some land where I'm hoping to do some things, and we have nothing on it. It's just land. So I have signed up for this thing where for signing up, you get 1 entry. But for everyone who signs up, everyone in North America who signs up using your link, which I've just dropped in the chat, I get an extra 600 entries. I am currently sitting at over 500,000. The current number is 558,644 entries.
Ian,
so
that's
I'm
insane.
It is. I kind of feel bad for everyone else in the contest, but at the same time, so they post on Facebook like, "Hey, we're having this draw for the Gundies," and there's a lot of people who are like sympathy posting on that, and they're like, I need this because, and the thing is that they seem to be like manipulatively sympathy posting, and the reason why I say that is there's a person going, I need this so that my homeless sister can live on our property, and like this will be great for that, and so I was curious. I followed their Facebook thing, and they also posted a whole bunch of memes about how awesome it is to be an only child, and so I'm like, oh, you need this for your sister, do you?
So that's a thing.
So, yeah. I was just like, oh, okay. So that made me a little less concerned about the sympathy posting, but yeah, I'm hoping to win that, and then the ideal would be to be able to get power to it and to stream from the bunkie. And so there might be content of me streaming from an undisclosed location in the woods.
And by undisclosed, I mean, good luck finding a fucking place.
I mean, if somebody's sufficiently diligent, they probably can. But at the same time, it's what is it? I would not recommend going to visit me unannounced.
No,
it'll be like, oh, right, let's go visit the heavily armed weirdo.
Not a really great idea. And especially if that first knock on the door, on a property, on a bunkie, that's not a pleasant way of saying hi. It's just not. So let's avoid that.
I also, as the chat is noting, do need to build an outhouse for it. Although the first outhouse is literally just going to be, I dig a hole.
And then you fancify that up by putting some 2x4s in the ground so you can like, hold yourself up a little bit.
Well, at first I'm going to build a hole with a what do you call it? With a seat and a little tiny structure. Like I will totally do that. I'm probably going to build it out of like pallets, because who cares if it's nice? It just needs to, survive. But
function.
Yeah. The other thing, by the by, is that my travels always go interesting. So yeah. Jen Labs Wine is asking, did Mrs. Runkle give an opinion on the 100 acres name? It might end up being named 160 Acre Wood. As like a nod
I kind
to
of like that.
Yeah, I kind of do too. Somebody else suggested the Brambles, which is pretty good. So
got a lot of options, bud.
Yeah, it'll be fun. So, but she does kind of like the 160 Acre Wood thing. Mrs. Runkle actually really likes Winnie the Pooh stuff. So
that's kind of winning it for me right now too.
So
now,
yeah,
it would be very maybe not great if you ended up shooting bears on the property.
I mean, the hunting rules basically say that you can shoot bears on your property whenever you want to, and the reason why is because if you've got bears on your property, you might not want to have bears on your property.
Yeah.
So it's like,
I know,
it's not so much hunting as it is like, if you have a bear that is, menacing you, then yeah. So
just not Winnie the Pooh bear.
We don't really. Winnie the Pooh.
I'm kidding.
Wasn't Winnie the Pooh a grizzly?
I mean, yeah, but I mean, you know what I mean? It just, oh my God, the poetic.
Yeah.
That's what I'm talking about.
We just have black bears out here.
Yeah.
So.
Okay. Well, go vote for Runkle to get a bunkie. Please do it. I've voted a lot. It's a lot of fun. I really want this damn thing. It looks really cute. I was selfishly looking at it for myself, and I was like, no, I don't have a chance. Plus, where would I put it? Runkle needs this damn thing. So,
and let's first things first. I'll win one, and you can win the next time they have a contest.
Yes, that's a great idea. Maybe I can put mine on your property too, and then I can have a place and you can have a place.
I like this would be entirely down with that. Like, hey, here's where Rob stays when he comes to visit.
Yeah, I like this idea. This is a winning idea.
Bring the littles out. They can go running around in the woods, and I like this idea. So we'll have to make this happen sometime.
Okay. All right. One more chat on the going out. Francie Lou Who got a job offer today. Have a great weekend all. Congratulations. What a way to go out. All right, folks. That's going to wrap for us this evening. Thank you for being here. Much appreciated. We went through all of our topics. We hit all of our topics. I can't believe it. Glad to have you guys here. Have a great weekend. Go out there, make something, do something, build something. You will feel better. You will be better for it. Quinny Bly, trying to get in for the last one. We had a box with a toilet seat and a movable shed on our family lay block in the middle of a mountain. Had a possum nibble my toe. Well, that sounds delightfully slightly terrifying. But yes. All right, folks. Enjoy it. Thank you for being here. Thank you to the mods for putting in all the time and effort. Much appreciated. Again, catch you guys next week. Hopefully. Best wishes to Runkle on his travels. And guys, have a great weekend.